Ms. Merrifield.
Good morning, Your Honor.
Good morning, ma'am.
I have two on today's docket, Judge. Brady Merrifield on behalf of Valerio Ladon de Deavara. Mr. de Deavara is present in 25 CF 812. We have reached an agreement, Judge, if I may approach.
Granted.
Just stand there. The PCI contract's on the back side, Judge.
All right, thank you.
And Judge, Mr. de Deavara in 25 CF 812 is withdrawing his previously entered plea of not guilty and entering a no contest to the terms listed in the agreement and the pretrial intervention program.
And that's the state's agreement?
Yes, Your Honor, it is.
All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? Yes. All right. You can put your hand down. Now, in this case, you've entered into a pretrial intervention agreement. That agreement requires you to make a plea to these charges. Do you understand that?
Yes, I do.
And you heard what Ms. Merrifield announced, and you signed the written plea agreement.
Yes, I have.
How old are you?
I'm 64.
And how much education do you have?
College education, sir.
Are you able to read and understand the plea form?
Absolutely.
Did you do that before you signed it?
Yes, I did.
Now, this is a little bit of a different sort of plea because it constitutes what we call an open plea to the court, which means that you are pleading no contest to the charges without an agreement regarding what your sentence might be. Do you understand that?
Yes.
Do you understand by pleading no contest, you're telling me that you believe, should you go to trial, the state would have the evidence necessary to convince the jury of your guilt, and you're not going to contest that?
That's correct.
And do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
Yes, I do.
And in this case, the agreement is that you will enter into and complete the pretrial intervention that has been detailed on the separate agreement that you, the state, and the probation officer have signed. Do you understand?
Yes, I do.
And if you complete this agreement, then this case will be dismissed.
Yes, I do.
And if you fail to complete this agreement, then you will be returned to the court for sentencing. Do you understand that?
Yes, I do, sir.
And that sentencing is without an agreement as to the terms and conditions of that sentence. And what does the defendant's score sheet show as far as points, Ms. Merrifield?
Judge, I do not have a score sheet. Do you have an extra? That's my apologies, Judge. I didn't know a score sheet needed to be turned in for pretrial intervention.
Well, we won't turn it in, but I want to be sure the defendant knows and understands what the potential outcome is in the event he fails to complete the PTI.
That's correct, Judge. Doesn't have any criminal history eligible for inclusion, so it'd be 36 points, no presumptive score.
And the 36-point score was discussed with Mr. de Deavara prior to entry or signing the plea.
While it's not a presumptive prison sentence, he does qualify for a prison sentence being more than 22 points, correct?
I understand, Judge.
And so the maximum potential sentence is 5 years in the Department of Corrections or any other sentence the court feels appropriate under the circumstances should you fail to comply with the PTI. Do you understand?
Yes,
that?
I do, sir.
Ms. Merrifield answered all your questions about the plea and how the plea affects you.
Yes, she did.
And are you satisfied with how Ms. Merrifield's represented you in this
I
case?
am, yes.
The court will find the plea to be freely and voluntarily entered into and will accept the plea which constitutes of your completion of the PTI with a dismissal, and your failure to complete that will be returned to you as an open plea to the court for full sentencing.
Yes, sir.
Thank you now.
All right, so now you're just going to this table right here so the gentleman with the other tie. And Judge, the last case I have, Brady Merrifield on behalf of Robert Marshall, 25 CF 175. There's a waiver on file for Mr. Marshall. As the court may recall, when we were here at pretrial conference, we had completed all of the depositions and anticipated an offer, and the court allowed Mr. Marshall's presence to be waived if that offer had not been conveyed. Mr. Gomez and I need to put our heads together one more time. I do need to get that final offer, so I am requesting to continue it with the understanding that we are going to bring this in on a miscellaneous for a change of plea, Judge.
Stay.
Yeah, that's correct, Your Honor. If we could get October 16th, I anticipate getting this offer no later than Friday of this week.
16th would work for me, Judge.
All right, so 10/16 at 9 o'clock.
No
for his change of plea, is that what we're saying?
Yes,
Okay, all right, very good.
and I believe that's all I have.
All right.
Thank you, Judge.
Ms. Merrifield. Mr. Geisel. Granted.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
And we'll address the status of the case going forward at that hearing, okay?
Thank you, Your Honor. Appreciate
All right,
it.
thank you.
Thank you, Josie.
And then before we get too many others, I believe I want to announce to all the members of the bar, don't forget, we have a bar meeting on the 17th. It's a special event. I'm not sure if we got somebody else from the bar now, right, to announce the attendance, but it's the 17th. You can address it at the bar. I believe it's at the community bank event. They're going to get, and there's CLE available, so that's available for the bar, and you can purchase your tickets on the online. What's the event that the bar is using now? So, but love to see all of you there. Okay. All right, Ms. Dudley. Mr. Mitchell?
My name is Gene Mitchell. I should have written that on your page there. I'm here with Mr. Marsh, who's represented by Lauren Henderson. I spoke
Say again?
Marsh, M-A-R-S-H. I
Marsh.
spoke with the gentleman from the state attorney. Here he comes. Ms. Henderson has asked me to ask for one cycle delay, and she has reasons. She's selecting a jury with Judge Miller right now in Escambia County.
Yes, Your Honor, I think originally the hope was that this case would be moved into that court with the other cases. Doesn't seem as though that's for sure going to happen. I know they want to depose the victim. I think that's scheduled. And so the state has no objection to a continuance.
All right, full cycle continuance?
Yes, Your Honor.
All right. All right, so Madam Clerk, that'd be 11:10.
Yes, sir.
All right, 11:10. Stay in touch with Mr. Henderson and be back on 11:10. Thank you now. Good day.
Just wait 1 second. Here comes Mr. Schneer. Judge Stone, as he's coming out, I'd like to say publicly, I've said privately to him, but to you as well as to the assistant. The other day on September 10, I was sitting in my office. I was waiting for my little brother's birthday party. I was blissfully allowing myself to think that my Okaloosa case was September 11th. I just messed up, and I'm so sorry, and
all right,
sorry
sir.
for any anxiety it would cause my client, or frustration it would cause you, or the Assistant State
Well,
Attorney.
Mr. Mitchell, if that was happening every time you were here, I'd be upset, but it was unlike you, and that's the reason I just said it for today. So we'll just move forward. Mr. Patel, I just made an announcement about the bar meeting, and I'm not sure I got the details correct, so.
Thursday, Wednesday night, 5:30, community event.
And it's Eventbrite, right?
Yes.
The tickets are available.
They can contact me, I'll be happy to guide them.
All right, thank you.
Thank you, Judge.
That's what I thought we were doing. Credit for time served concurrent with the state time, right? Right.
All right, so you need Mr. Schneer in the interview room, Mr. Mitchell?
Yes.
Okay. Mr. Swiatek.
Morning, Your Honor.
Good morning.
This is Pilar Spielman in case 23 CF 1529.
Okay.
I have an agreement with the state to continue this one time and set it for trial.
All right. So trial certain next cycle.
Yes, sir.
All right, so what, do we have an offer that's on the table?
We have an offer that we're, too much distance between here and there to get to.
Okay, what is the offer, just so I can be aware of what it is?
It was 5 years of probation, and the restitution was the exact number of, it's 40,000 in that area, and of course, paying the restitution. That was the offer.
And just standard terms and conditions?
Yes, sir.
Well, all right, so the matter's continued, and no further continuances will be set for trial next cycle.
Yes, Your Honor, thank you.
So 11:10. Thank you now. Anything else, Mr. Swiatek?
No, Your Honor. That's all.
Okay, thank you.
Thank you.
Mr. Flowers.
Judge, good morning, sir.
Good morning, Mr. Flowers.
First matter, Frederick Vaughn. In speaking with the state, we anticipate that if you were to place this on October 16th miscellaneous, it can be disposed of on that date. That sounds right, right?
So change of plea on the 16th?
That's what we anticipate, Your Honor.
All right, 10/16 at 9 a.m.
The other matter I have is Star, STARR. I'm asking likewise for October 16th. We anticipate a change of plea.
State?
That's correct, Judge. We have no objection.
All right.
No, that's what I have.
10/16 at 9 o'clock.
Your Honor, may I approach, please?
Granted. All right, Mr. Shaw.
Morning, Judge.
Good morning, Mr. Shaw.
Judge, I have Javon Mello, MELLOW, 24 CF 2659. I'd ask to put that on the November date, Judge.
All right, well, what's going on?
We had thought we had it, well, we had hoped to have it worked out today. I had to go out of town the last part of last week, and we
okay.
didn't get it resolved.
All right. Understood. State, any objections?
No objection, Your Honor.
All right, it'll be continued 11:10.
Judge, and the docket that I printed out had Brett Bay on it as well, 21
Yes.
CF 653, but I think that was already continued, so I just want to bring it up just to be safe.
Yes, I show it as already continued.
Thank you, Judge. I believe that's all
All right, thank you now.
Thank you.
Mr. Wilkins.
Good morning, Your Honor. Jack Wilkins for Sarah Newton. Your Honor, I've been speaking with Mr. Gomez. We are anticipating this to be a PTI referral. We just simply need to get paperwork exchanged and a final contact with the alleged victim in the case.
And that is correct, Your Honor. It will be a PTI. I'm just attempted 2 times to call the victim. I'm trying to make sure I exhaust all that before we actually formally enter the PTI.
All right. And so it'll be PTI status on 11/10.
Yes, sir. It should be resolved prior to any other further court appearances.
Very good.
Thank you, Your Honor. May I be excused?
Yes, sir. Good to see you in my courtroom again, Mr. Wilkins.
You too, sir. Have a good week.
Mr. Levy.
Good morning, Judge.
Good morning, Mr. Levy.
James Levy on behalf of Brittany Nicole Smith. It's 2 cases, 2025 CF 1203 and 2025 CF 1204. And Judge, I've got a signed stipulation here that will get filed, and I also have a proposed order that I can either hand to you today or...
Yeah, hand both of them to me. We'll get it done right now.
Okay.
Done in open court takes care of it right now, right? Granted. All right, and so what I have is a stipulated motion for substitution of counsel by Mr. Koch and Mr. Levy, and I'm executing the order now, relieving the public defender.
And Judge, I've talked with Mr. Snell. I'm going to be getting the discovery this week. And if depositions are necessary, which I think they will be, I would try and get those scheduled before the next pretrial, but I would ask that we get it continued to the next pretrial.
No objection.
All right, it'll be continued. Is there an what's the PTI you say? Is that what we're doing?
There was an offer, Judge, but I need to look at the discovery. I believe there was an offer at the arraignment. So
What is the offer, if you would restate it, please?
It was the 3 years of probation with the standard conditions.
All right, very good. And we'll continue the case then 11/10. Stay in touch with your lawyer, be back in court on the 10th. Thank you now.
Thank you, Your Honor.
Thank you,
That's all I
Mr.
have.
Levy. Good day, sir. Mr. Ramey, please.
Good morning, Your Honor.
Good morning, Mr. Ramey.
May it please the court, Judge, this is State of Florida versus Amanda Christine Shaw, 25 CF 939A. We have entered into an agreement for PTI and a plea based on conditions in the PTI. May I approach?
Granted. If you'd raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
Okay, you can put your hand down. Now, you're entering a plea today because you're entering into a pretrial intervention agreement. Do you understand that?
Yes, Your Honor.
And so that makes it a little unusual because the plea would then constitute an open plea to the court. And I'll explain that to you in a little bit. Did you read and sign the plea form?
Yes, Your Honor.
How old are you?
37?
Okay.
37?
That's
The older
okay.
I get, the harder it is to keep track.
Oh, I know. Well, wait a few years. And you want to stop. How much education do you have?
College associate degree?
Okay, you able to read and understand the plea form?
Yes, Your Honor.
All right. Now, the plea that you've given me constitutes a plea of no contest to these charges. Do you understand that?
Yes, sir.
And that says to me that you believe the state has the evidence necessary to convict you of this charge, and you're not going to contest that. Do you understand?
Yes.
And by making this plea, do you understand you're waiving your right to a trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
Yes.
As to the sentence, so to speak, by this plea, you are agreeing to enter into the pretrial intervention agreement with the specified terms and conditions which you, the state, and probation have signed, and those conditions are outlined in there. Have you read and understood those terms and conditions?
Yes.
Do you understand that if you complete the pretrial intervention as provided, then the case will be dismissed?
Yes.
Do you understand if you fail to complete the pretrial intervention based upon the plea you're making today, then you'll be returned to court for sentencing in this case?
Yes.
And what does the defendant's score on the score sheet?
36 points with a maximum of 5 years. She doesn't have any prior criminal history.
All right, so the defendant does qualify for a state prison sentence, having scored over 22 points, but not a presumptive sentence, correct?
Correct.
All right. So the reason I mention that is that you are eligible for up to a 5-year sentence in prison if you fail to complete your pretrial intervention agreement. Not saying that's what I will do, but you need to understand that that's the possible outcome. Do you understand?
Yeah.
All right. And any other range of legal sentences are available if you fail the PTI and are returned here for sentencing. You know, now, you're saying yes, but you have a big question mark on your face. Do you want to talk?
Yeah, I just have
Do you need to talk to your lawyer a little bit before we continue? The reason I'm asking these questions is it's important that you're making a free and voluntary decision. It can't be a free and voluntary decision if you don't know and understand everything about the decision you're making. So if you need to talk to Mr. Ramey, he'll answer your questions and we can go further. It's not a problem for me. That's part of my job. It's important you know and understand. With that brief moment, do you understand what I'm saying now?
Yes, sir.
Okay, so it's completely, if you fail PTI, it's completely up to me what sentence would be imposed if you're returned to court. Do you understand that?
Yes, sir.
All right. And with that amount of time, has Mr. Ramey answered all your questions about the plea and the PTI and how they affect you?
Yes, sir.
And are you satisfied with how Mr. Ramey's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you. Thank you, Mr. Ramey. You have one other, don't you?
No, sir, unless I have it wrong on my calendar.
Well, and as you know, we're struggling with our records right now. So, Madam Clerk, do we have another one for Mr. Ramey, or? Okay, do we have it? Do you have another one with me on a different docket, maybe?
Yes, sir.
Ah, okay. All right. Thank you very much.
Thank you, sir. Pleasure
Safe
to see
journey
you, sir.
home.
Great to see you.
You too, Mr. Ramey. Mr. Patel.
Good morning, Judge.
Good morning, Mr. Patel.
There are several cases on the docket.
And sorry to startle you with you making the bar
That's
announcement
okay.
there, but
It's Monday. I wouldn't have it any other way. I have several cases on the docket. However, we continued most of those.
well, let me tell you what I got. I got Andrew Lamantia, and it showed, my notes indicated that you did a DPA on 9/8, so I don't know, is it on or off?
Should be off with the
Madam
tendering
Clerk.
of that docket.
I do not have it on my docket.
All right. Next, I have, no, Yule was continued to 11/10, correct?
Correct.
And then I have Alexander Wallace, but I show a DPA on 9/8 on that as well.
No, I have the DPA right now.
Okay,
May I
so.
approach?
Yes. That was, so it's DPA on docket day. All right. All right.
That should take care of everything.
Yes, it does.
Thank you, Judge. May I be excused?
Yes, sir. Well, hold on a second. I guess if you'd approach. Thank you very much.
Thank you.
Mr. Durrell.
Morning, Your Honor.
Good morning, Mr. Durrell.
May it please the court, Dustin Durrell on behalf of Mr. Jonathan Wright. Your Honor, I did meet with Mr. Snell on this case. We do have an amended offer from the state. I would ask for a continuance to discuss that offer with my client. I have not been able to relate it to him yet.
All right, what is the amended offer?
It is a lesser included misdemeanor, criminal mischief, restitution of $300, count 2, the resisting as charged, with, I believe it was 6 months probation. Is that correct, Mr. Snell? Yes, Your Honor. All other standard conditions would apply.
All right. All right, so full continuance, and then you'll advance it if you have a deal?
Yes, Your Honor.
State?
That, no objection.
All right. That's continued, 11:10, and let us know if you get that plea, and we'll put it on any time.
I will, Your Honor. Thank you very much.
Thank you, Mr. Durrell.
I believe
Mr.
that's all I
Cobb.
have. Thank you.
Ms. Reed, are you on the docket?
Well, I unfortunately was a little tardy this morning, so but if the court would like
Well,
to take me out.
we'll put you here next. All right. All right.
Thank you, Judge. I have 2 cases on this morning's docket. They were set for change of plea. The first case I have, Your Honor, is Autumn Renee Lusty. That's 25 CF 378. I was not able to work out the mechanics to get my client in to sign the plea. It is a plea to 2 misdemeanors. So I would just ask, Judge, if we could put this on the 10/16 court date. I spoke to Mr. Gomez. He's okay with that. Just for a change of plea, my plan is to have the written plea and abstention submitted to the court prior to then, but I don't want it to fall off.
Okay, 10/16 at 9 a.m.
Okay, Judge. And then the other case that I have, Your Honor, is Jonathan Ryan Smith, and that is 25 CF 532. I do have a written plea agreement this morning. However, in speaking with Mr. Snell this morning, there were 2 changes to the terms, so I would like to, instead of my initials being crossed through the written plea agreement, I would like for my client's initials to also be next to those changes. So I would also ask for 10/16. It's a plea to misdemeanor, so I anticipate doing a written plea and abstention prior to that court date. However, want to keep it on for control.
Go ahead.
Senator Jordan Hunt in the courtroom.
All right, 10/16 at 9, and then if you advance it sooner.
Great, thank you, Your
All
Honor.
right, thank you.
That concludes my business. May we excuse?
Yes, ma'am.
Okay,
Thank you very much, Ms.
thank you.
Reed.
Thank you.
All right, so Mr. Cobb, Mr. Nopes. Say again? Thank you.
Your Honor, is the jail on Zoom yet?
Checking now. Mr. Cochran. No.
Okay. I have that signed plea whenever they're ready, Your Honor.
Sorry, Judge, that's why you said to talk.
Do you need that time, Mr. Cobb, or you want to dispose of your other cases and then go back?
Well, I'm ready to dispose of the Quinton Powell case, but I need a little bit more time to talk with Mr. Rikio. But I can do Quinton Powell now.
All right.
Judge, this is State of Florida versus Quinton Powell and 2023 CF 2047. He's charged with trafficking in amphetamines or methamphetamines, 14 grams or more but less than 28. Trafficking in fentanyl, 4 grams or more but less than 14, in possession of controlled substance. He's going to be withdrawing his plea of not guilty and entering a plea of no contest to the following terms and conditions. He'll be adjudicated guilty on all counts. And he'll be sentenced to serve 86.550 months, which is guidelines, and counts 1 and 2. And he'll be sentenced to serve 5 years as to count 3. That's a third-degree felony. All sentences will run concurrent, and the count 1, trafficking in methamphetamine, has a 3-year minimum mandatory, and the count 2, trafficking in fentanyl, has a 7-year minimum mandatory. He'll receive credit for all time served. Can I approach?
Is that the state's agreement?
There's a mandatory fine of $50,000, but we'll never pay that. I don't know why, but that's, you gotta announce it.
Well, also after, there's a surcharge that goes on top of that.
Yes, sir.
Clerk's surcharge of 5%. Is that correct, Madam Clerk?
That's correct.
You just run that for every. Now can I approach?
Granted. Any score sheet objections?
No, sir.
All right. Mr. Powell, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay. Now, you heard what Mr. Cobb said, and you signed the written plea form.
Yes, sir.
All right. And how old are you?
36.
And how much education do you have?
GED.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what Mr. Cobb just announced to me what you read in the plea form?
Yes, sir.
Now, do you understand that you're pleading no contest to the announced charges?
Yes, sir.
And by doing that, what I understand you to say is that you believe the state has the evidence needed to prove your guilt to a jury, and you're not going to contest that.
Yes, sir.
Do you understand by making this plea, you're waiving your right to that trial by a jury where the state would have to prove your guilt beyond a reasonable doubt?
Yes, sir.
And you understand that, I think last week when we were here, it was announced that the case was ready for trial, and that we actually set it for trial. I know that you were in another facility and you got transported over here. Is that what happened?
That's correct, Judge.
And you're pleading to 86.550 months in state prison instead of going to trial. Do you believe, considering all the things, that this is the best outcome for you under the circumstances?
Yes, sir.
Okay. And can you tell me briefly why you think this is better than going to trial?
I don't. I'm looking at 30 years if I lose.
Right, 30 years on count 1, 30 years on count 2, and 5 years on count 3, right? So you think the certainty of the 86.550 months versus the uncertainty of what sentence you might get if the jury convicted you is one of the reasons you're doing this?
Yes,
or the
sir.
principal reason?
Yes, sir.
Okay. Now, has Mr. Cobb answered all your questions about the plea and how it affects you?
Yes, sir.
Are you satisfied with how he's represented you in this case?
Yes, sir.
Now, are you under sentence in the case in Santa Rosa County or in another case? There was some confusion in reading my notes, Mr. Cobb, or is that still pending?
Still pending. He'll be transported back to Santa Rosa County after this to wrap up that case, Judge.
Okay, all right. All right, then as I said, the court will find the plea to be freely and voluntarily entered into and accept the plea. If you'll step over this way, please, Mr. Powell. Thank you.
Judge, I do need to talk to Mr. Rikio a little bit before I bring him back to do the plea, so if I can pass him till just...
Yes, sir. Just let me know when you're ready.
Thank you, Judge.
All right, Mr. Mitchell, you ready with Mr. Schneer now? Yes. All right.
Yep.
May I approach, please?
Granted.
Judge Stone, we've had some defenses here. This was a house that were 6 or 7 people were in it. Certainly, we had constructive possession type issues. We had suppression hearings before the prior judge several years ago. We had asked the government if they might stipulate to the dispositive nature. They declined with regard to that. We think this is in our best interest. We tried to get better, but this is as far as we got. We think it's in our best interest, Judge. No contest.
All right, and the sentence is in this case is on count 1, it's the 7-year DOC minimum man, right?
Yes.
Count 2 is a lesser included trafficking, 893.1351C4 with a 7-year minimum man. Count 3 is the lesser included fentanyl trafficking, 893.1351C4B1, which is a 7-year DOC min man. On count 1, it's a $100,000 fine. On count 2, it's a $50,000 fine. And on count 3, it's a $100,000 fine. Count 4 is as charged, and that's 7 years Department of Corrections, but that's not a min man. And count 5 is as charged, and that is 7 years Department of Corrections and not a minimum mandatory. And the state, as part of this plea, once we're completed, is agreeing to null pros counts 5 through 9. All right. And is it?
It's on the page.
That's 79, Mr. Koch's case, though, right? Okay. All right. And so, all right, Mr. Schneer, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, you can put your hand down. Now, you've heard this discussion, and your attorney has tendered to me a written plea form. Is that right?
Yes, Your Honor.
Did you sign that?
Yes, sir.
All right, and how old are you?
I'm 49 years old, sir.
And how much education do you have?
In college.
Are you able to read and understand the plea form?
Yes, Your Honor.
And is what I just went through with your attorney in the state what you read in the plea form as far as the sentence that's to be imposed by this agreement?
I believe so, yes.
All right. And do you understand that by this plea arrangement, you're pleading no contest to these charges?
Yes, Your Honor.
And that says to me that you believe the state has the evidence necessary to convince the jury of your guilt, and you're not going to contest this.
No, Your Honor.
Okay. No, you're not going to contest it.
Yes.
Okay. Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
And in this case, the sentence will be as described. It is the 7 years min man on counts 1, 2, and 3 with the fines, and the appropriate fees and costs, Madam Clerk, would be?
$615.
All right, and then those fines would also have a 5% clerk surcharge on top of it. And it says concurrent with any other sentence from April 10 of 23. What is that?
The court will recall Mr. Schneer was in federal custody. Mr. Schneer worked hard to get himself brought here from federal custody. And that's the spirit of this agreement, is that this, from the state standpoint, be concurrent with his federal sentence. And additionally, may we please approach, may the state and I approach?
Yes.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right. Now, considering the substantial sentence that you're pleading to, why would you choose to plea and accept this sentence versus exercising your fundamental right to a trial by jury to make the state prove the case against you?
Why would you let, why? You know English.
Yeah,
Well, it's not a trick question. You know, when you're pleading to 7 years in state prison as a minimum mandatory, and I realize that's concurrent with your other sentence, but why would you do that as opposed to going to trial and making the state prove their case? Okay, so let me see if I restate that another way. As charged, you were facing 30 years on count 1, 30 years on count 2, 30 years on count 3, 15 years on count 4, 15 years on count 5, 15 years on count 6, 15 years on count 7, 15 years on count 8, and 1 year on count 9. So you're getting the 7 years minimum mandatory certain versus going to trial and possibly facing, well, that's more math than I could do in my head, but 130, 60, 76 years. Okay, so you'd rather do the 7 years than the 136. All right, so that's the principal reason you'd accept a plea to 7 years in state prison as opposed to going to trial, because you know what the sentence will be, as opposed to not knowing if you go to trial. Okay. Has Mr. Mitchell answered all your questions about the plea and how it affects you? And are you satisfied with how he's represented you in this case? The court will find the plea to be freely and voluntarily entered into and will accept the plea. Now, Madam Clerk, did I recite the fees and costs and the fines correctly, including the surcharge?
Yes, sir.
All right. Thank you very much.
Did you recite the gain time, the credit for time?
Yes, credit for all time served. You have 889 days here, but my understanding is that will actually be calculated. I'll announce it at 889, but then that would cap it at 889, and I don't know if that's the correct number.
Okay, fair enough, Judge.
Yeah, so it will be credit for all time served, and I think that is what we're saying is from April 10 of 2023.
Yes, sir.
Right, so I'd rather say from April 10 of 2023 than count the numbers, because you may actually be.
Fair enough.
All right? All right, all credit for all time served from April 10 of 2023.
Judge, I'm ready to go with Mr. Rikio if I can.
Yes, sir.
And Judge, I spoke to Mr. Noakes, and he had Walton County first. He told me to tell you that his GPS
Yes, sir.
says 1030.
I saw that after I announced, called for him. I saw it.
Salvador Rikio. Judge, this is State versus Rikio in 2024-2275. He's charged with one count of possession of burglary tools, a third-degree felony. Count 2, burglary of an unoccupied conveyance, it's also a third-degree felony. And count 3, criminal mischief. He's going to withdraw his not guilty plea and enter a plea of no contest. He'll have a withhold of adjudication with regards to count 1 and 2 and be placed on 5 years probation with the Department of Corrections. Count 3, he'll be adjudicated guilty and sentenced to time served. With regards to counts 1 and 2, there is an agreement on the table that he can early terminate automatically if he pays his restitution off, which is $1,800, and or takes the oath of enlistment and presents paperwork that he's going into the military. So if he did all that in the next 3 months and enlisted in the military, this plea allows him to terminate early, but it does have 5 years in the event that he needs that time to pay off the restitution. And the restitution is $1,800. He'll have $100 a month he'll have to pay towards restitution. No alcohol or drugs. He's got to maintain a job or 5 job applications per week, or obtain his GED. And if he's doing his GED, then he doesn't have to work if he's taking the classes towards the GED. So I believe that's the terms of the agreement. I just need to get him to sign it really quick.
Yes, sir.
Then I have a score sheet, total sentencing points of 26. Can I approach?
Granted. All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, and you can put your hand down. You heard what Mr. Cobb said, and you signed the written plea form.
Yes, sir.
How old are you?
19.
All right, and Mr. Cobb's told me that you're working on your GED, so you haven't completed high school, but how far did you make?
I only had 4 more credits.
Okay, yeah, with that, you able to read and understand the plea form?
Yes, sir.
All right, did you do that before you signed it?
Yes, sir.
And is what you read in the plea form what Mr. Cobb just announced?
Yes, sir.
All right, do you understand that you're pleading no contest to the announced charges and waiving your right to a trial by jury?
Yes, sir.
All right, and you'll be on 5 years of probation with the standard conditions. However, that can be terminated based upon those special events that were announced.
Yes, sir.
However, that doesn't eliminate your obligation to pay the restitution or your court costs. Do you understand?
Yes, sir.
And so the reason I mention that is, although that may be a good event for you to get terminated, then those costs may end up in a judgment, which may have some negative effect on you otherwise. So if you don't take care of business on those things, even after your probation is terminated, it will come back to haunt you. So I would say if you make that deal, get with Mr. Cobb so he can ask for an order for a period of time to get those things paid off so it doesn't get to a judgment. You understand what I'm saying, Mr. Cobb?
Yes, sir, I do.
All right. And you'll have to make time to get those things paid off so it doesn't get to a judgment. You understand what I'm saying, Mr. Cobb?
Yes, sir, I do.
All right. And you'll have to make those payments, otherwise the clerk's going to send it to a judgment and then negative things happen for you, okay?
Yes, sir.
All right. The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Thank you, Judge.
Now, probation's going to give you a notice. You've got to report to them as soon as you get out, and if you get out in enough time today, then you got to report today. Otherwise, it has to be first thing in the morning.
Yes, sir.
Judge, I had Darby Boudreaux on the docket today, but I don't know if it's on the docket today. It's the case that seems to last forever, but that was so she could pay restitution. And I know last time we checked, I believe last Monday, she only had $800 left to pay. And if that is the case, I'd like to give her another month or two to come up with $800. So
I
she can-
don't have her on the docket today.
Then I just said all that for nothing, so that's good.
Okay, all right.
All right, thank you.
Well, no, with what's going on, it's better that you mention it than not.
Yes, sir. All right, have a good day, Judge.
You too. Good morning, Mr. Early.
Good morning, Your Honor.
All right, Jesse Wayne Lacoste.
Your Honor, talking from Mr. Lacoste. He is currently incarcerated in Escambia County. We are, at this time, moving forward with his cases in Escambia County. There has been an offer from the state to take care of this case in Okaloosa County. I'm going to take that to Mr. Lacoste, but at this time I would be asking for a continuance. We are moving forward. He has like 7 cases in Escambia County. We were slated to try one, I believe, in July. It ended up getting passed due to some discovery issues, but he's coming up in the next couple of weeks in Escambia, and I do feel that we will be moving forward on his Escambia cases, and after that's done, we will be able to bring him in for a landing in Okaloosa, Your Honor.
All right. Any objections to the continuance?
No objection, Mr. Statement.
Okay. And so if you are able to get the plea arranged, do you all agree to transport him? Or I'll even, if you can get the written plea, Mr. Early, and I'll take his plea remotely if you can make those arrangements from Escambia County so we can go ahead and dispose of this case.
Yes, Your Honor. That's what we plan on doing. Mr. Lacoste has, I think it's 8 to 10 open cases between Escambia, Santa Rosa, and Okaloosa. Of course, you know, we do think that we're going to have to be in a trial, or we're going to have to try some of those cases, but I do believe that we might be able to bring in a resolution on this case here. I do think Mr. Gillespie was waiting on, for the state, was waiting on Zoom as well. He might not have made it into the meeting, but this is something that we've talked about. This is something that we've talked about, and we've been working on Mr. Lacoste for over a year now, Your Honor. So we are trying to get it resolved as quickly as possible.
I apologize. I have Mr. Gillespie now.
Yes, sir.
I apologize, Mr. Gillespie. I let Mr. Early in, and he was just telling me the status of Mr. Lacoste and indicating that he's set for trial, and I was saying, well, if you work a deal out, then and get me a written plea, I'll take it remotely if we can work that out on our Okaloosa cases. He doesn't need to be transported if we can work that deal out.
Yes, Judge, I sent over a plea offer, and Mr. Early and I were talking about maybe trying this one first, but in the scheme of things, I don't think we're going to be able to do that. We're going to try the other one, I think, at this point in Escambia at this stage, or at least this will be a continuance.
All right. Yes, that's what he indicated. But I'm just saying I'm open to do that if that'll help you move things along.
Yes, sir.
Okay.
And Your Honor, we will be going to talk to Mr. Lacoste about that plea, or I will be going to talk to him about that plea. And if it's something he indicates he wants to do, I will let Mr. Gillespie know, and of course, contact your office to get it set.
Perfect. All right. 11:10 then, and remote will be permitted considering the circumstances.
Thank you.
Thank you, Your Honor.
All right. Thank you.
Bye-bye.
Judge, I have one more with Mr. Cochran, but I can wait.
Mr. Cochran?
Yes, Your Honor. We're hearing Mr. Neil Scott.
Scott. Last name Scott?
Yes, Your Honor.
It should be last name's Neil, first name's
Neil,
Scott.
sorry.
Case number is 22
Scott
CF.
Neil, right?
Yes, Your Honor, sorry.
Yes.
Okay. And I think we were supposed to, y'all were supposed to meet and get together on a scheduling order, correct?
Yes, Your Honor, the state sent it over. I have no objection to it.
Okay, I will go ahead and send it into Your Honor. It's filed as an order. It's got the trial dates for January 26th as a scheduled trial date, and it has a list of dates for depositions and discovery, anything additional. So I'll send that as an order to the court, if that's appropriate, and get it signed, and we'll move forward.
Should we set this then for the 11/10 as a status, or just rely on the, set it for January 12, since you're agreeing that it's going to be on the, that trial week?
I'm fine with leaving it for a status. If I can appear remotely, I think that'd be ideal.
Yes, Your Honor.
Okay, all right, so we'll set this then for status on 11/10, and yes, you can appear remotely, and if there's any issues with the scheduling order, let me know as well, all right? And I'll, if you'll submit that through the portal as a proposed order.
Thank you.
Thank you, Mr. Gillespie. Anything else?
No, Your Honor, thank you for letting me appear via Zoom.
You're welcome, sir. Good day.
Thank you, Your Honor.
All right, Mr. Cochran, you ready? I think we're still waiting on Mr. Nope, so.
Your Honor, first I have Mr. Anthony Brown. I believe he refused to be transported this morning.
That's my understanding, yes, sir.
Yes, Your Honor. And candor to the court, it's more of a, I told him he wouldn't have to be transported, but I get out of the jail super late, so I wasn't able to get people off the transport list.
Okay.
Your Honor, at this time, we're going to continue. There's some things that he wants me to look into, so I'd ask to leave this set for the November 12 date.
All right. Did we dispose of the stand your ground motion? I can't recall.
I do not believe so, Your Honor. I have not. It was being handled by another attorney in my office. I will go back and verify, but I have not seen anything about stand your ground being addressed.
All right. All right, so we'll set it to 11:10.
Okay. Mr. Antonio Lee, Your Honor, that is the one we're waiting for the jail to be on Zoom.
Yeah, they're not here yet.
And that will be a plea whenever he appears.
Okay.
Mr. Michael Lee, Your Honor, he's present and approaching.
Good morning.
Your Honor, at this time, I'd like to set this for November 10. We're in negotiations with the state. The state needs to speak to law enforcement.
That's correct, Your Honor.
All right, it'll be continued 11:10.
Thank you, Your Honor.
Thank you, sir.
Thank you, good day.
That's it. If I could pass over Mr. Lewis at this time, Your Honor. I have Mr. Zachary McLean. He's present and approaching. Your Honor, I'd ask to set this for 11:10. We're in negotiations with the state. There's just a question over one term that my client wants me to go back and look over.
State. All right, it'll be continued 11:10. Thank you, Mr. McLean. Good day.
Mr. Scott McKean, he's present, Your Honor. Your Honor, at this time I'd ask to set this for 11:10 pretrial. We've been in negotiations. I don't know if we're going to be able to resolve it, though.
All right, because my notes indicate that you felt like restitution was the big issue, right?
Yes, Your Honor, and I spoke to my client again Friday after we made some headway on that, and as of right now, my client is not accepting that offer.
Okay, is it just the restitution that's troublesome or the whole offer?
I think it's the whole offer at this point, Your Honor.
Okay, all right, so the only reason I'm saying that is, 1110 will be almost a year, and think about moving the case onto a disposition at that point
Yes, Your
in time. Okay.
Thank you for the attention of both parties.
I think, yes, Your Honor, we've done,
Trial, next cycle.
yeah, we've done our depositions.
Depositions are done, so you're ready to try the case if need be?
Yes, Your Honor.
Okay, all right, then we'll see you on 1110. Stay in touch with your lawyer.
Yes, sir. Next, I have Mr. Timothy McKeown, Your Honor.
McKenna, please.
Inmate. McKeown.
Say again?
Do you want to go inmates now?
Let's keep on with her out of custody first. Let's
Okay,
get
I have
her out
Stephen
of-
McLovich, Your Honor.
McLovich, please.
Your Honor, this is going to be a plea, except it contemplates my client going to jail at least for a couple hours so they can calculate his credit time, because it should be a credit time served. My client's not prepared to go to the jail today. I just told him to offer this morning. Is there a day that we could set it for him to enter the plea so he's ready to go? And he's aware that he's going to be going into custody for that day afternoon, for that evening?
Do it 10/16, Your Honor, or if you're okay with setting it later this week, I'm okay with that too, but.
Well, please approach. Okay. Well, 2:30 on Thursday, then we'll continue this to take the plea on 2:30 on Thursday.
Thank you for that, Your Honor.
You're welcome, sir.
And finally, Your Honor, at my out of custody, I have Miss Jennifer Nolan. Your Honor, I'm asked to set this for pretrial detention on the 10th, or I'm sorry, not pretrial, just the pretrial docket date on November 10, Your Honor.
Okay. And what's going on in this case? Is there an offer?
There is, Your Honor, there's a probation offer. I don't have the exact terms in front of me. It's a 2-year probation, substance abuse eval treatment,
That's correct, Your Honor.
community service. I don't know how many hours.
24.
24 community service hours.
Okay. Withhold or adjudication?
It'll be adjudicated.
Adjudication.
All right. And state agree to continuance?
Yes, Your Honor.
All right, very good. See you on the 10th of November, and stay in touch with your lawyer.
That's all that I have out of custody, Your Honor. Turn it over to my
And
that this was the guideline sentence 29.63,
That's correct, Your Honor.
and that everything was done. What's changed?
Judge, may we approach?
Granted.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve
It'll be
handmade
continued to
pastries, espresso, and
11:10.
lunch
No
items.
further continuances. Stay in touch with your lawyer and be back on the 10th, okay?
Yes, sir.
Thank you.
So make it. Yes. Next, Judge, if I may call, last name Ron, R-A-H-N, first name Christopher, in 25 CF 625. Judge, might have just a brief moment for a signature.
Yes.
Contest plea this afternoon. First, counts 1, 2, 4, and 5 are going to be null prost. Leaving count 3, the driving while license suspended misdemeanor. And the terms are going to be adjudication of guilt, supervised by JCS.
All right, raise your right hand, please. Do you swear to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. You heard what Mr. Koch said. You signed the written plea form.
Yes, sir.
You understand your plea. The evaluation recommended treatment, 24 hours community service, cost of investigation, and the appropriate fees and costs, which are, Madam Clerk,
$300.
plus the state-provided legal assistance.
Yes, sir.
Is that your agreement?
Yes, sir.
Mr. Koch answered all your questions about the plea and how it affects you?
Yes, sir.
You're satisfied with how he's represented you?
Yes, I have.
The court will find the plea to be freely and voluntarily entered into, and will accept the plea. Thank you.
Thank you.
Okay. This is where you report JCS. So do that right
Okay.
today.
Perfect. Thank you. You're welcome. Have a good day.
Judge, next, if I can call Mr. last name Sledge with an S, first name Daniel, who's present and approaching. And this is 25 CF 50, Judge. And you can sign right there.
substances without a prescription and no alcohol, random urine and breath testing, 50 hours of community service work at any. There's a 7 p.m. to 7 a.m. curfew that can be modified for school or work purposes. Maintain gainful employment or show proof of 3 job applications per week. With respect to count 2, there'll be an adjudication and time served. Your Honor, if I may approach.
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Okay, and you can put your hand down. You heard what Mr. Harper said on your behalf and signed the written plea form.
Yep.
How old are you?
38.
How much school do you have? Are you able to read and understand that before you signed it?
Yes.
And is what you read in the plea form what Mr. Harper just announced to me?
Yes.
Do you understand that you're pleading no contest to these charges?
Yes.
And that tells me you believe the state could prove your guilt and you're not going to contest that.
Yes.
Do you understand that you're waiving your right to a trial where you would have to make the state prove your guilt to that jury?
Yes.
In this case, you're going to be adjudicated guilty beyond 3 years of drug offender probation with the fees, costs, and other conditions that were announced. Is that what your understanding is?
Yes.
Mr. Harper or Ms. Jaquid answered all your questions about the plea and how it affects you?
Yes.
And are you satisfied with how you've been represented?
Yes.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. And if you'll step over this way, please.
The next one, Judge, is Brent Whitner, 24 CF 2028. I believe he also has a case with the Public Defender's Office.
Yeah, I show with Mr. McKinney.
That is correct, Judge. And he's usually good about showing up. I don't know why he's not here today. What we intended to do was input a restitution amount into the record for pay and dismiss, which I believe was the intention of all parties.
My case is a PTI recall, Judge, that we hope to resolve thereafter.
Do you want to try?
Do you want to just wait a little bit on the docket? And
Judge, if we could wait for a few minutes, I'll try to get it here.
okay.
Thank you, Judge.
All right. Mr. McKinney, you want to call your folks in the gallery?
Apologies, Judge. Judge, I have Sonny Taylor, if I can call some.
Yes, please.
Sonny Taylor, followed by Jimmy Thomas. Mr. Taylor is before the court in 25 CF 279. We have had discussions with the state attorney's office about our position in this case. It is going to need a continuance. We're looking at school options for Mr. Taylor to see how that interplays with potential reduction of charges. So that's going to a good place for Mr. Taylor. So if we could request a continuance to get more details about that.
Okay. Stay.
No objection.
All right. 11:10. Thank you.
Thank you, Judge. Mr. Jimmy Thomas, followed by James Trible. Mr. Thomas is here in 25 CF 1055. Judge, I had met with Mr. Thomas ahead of today. The state is making Mr. Thomas a downward departure offer for 36 months probation. I've discussed that with my client, and today he's indicated that he's wishing to seek private counsel, which would necessitate a continuance, but I cannot guarantee from my position that the state needs that offer.
All right. Well, what is the current downward departure offer?
36 months of probation, drug offender probation, with standard terms and conditions and code. I believe one of the holdouts for Mr. Thomas is the mandatory license revocation.
Okay. And so state agreed to continuance? be continued, 11:10.
Wait, hey. James Trible. Judge, this is Mr. James Trible Jr. before the court. He's here in 25 CF 567. This is a case that was on the trial docket. We have an agreement at this point. Mr. Trible will be entering a plea to a lesser included offense of misdemeanor battery. Madam Clerk, that is 784-03-1B. The agreement calls for an adjudication to the misdemeanor, 12 months of JCS probation, no contact with William Shea, SHEA. Madam Clerk, I've written in court costs for a misdemeanor of $622. Certainly correct me if I'm wrong. $150 cost of defense, $1,000 even restitution to William Dennis Shea, SHEA. While on probation, Mr. Trible must attend and complete anger management. There will be a standard JCS cost of supervision. May I approach with the misdemeanor plea?
Granted. All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do, Your Honor.
All right, you can put your hand down. You heard what Mr. McKinney said on your behalf, and you signed the written plea form?
Yes, sir.
Do you understand you're pleading no contest to the lesser included offense and waiving your right to a trial by jury?
Yes, sir.
You will be found guilty and placed on 12 months of probation with no contact with the named person, the fees and costs, and the restitution. And you must attend and complete the classes announced and have the cost of supervision. Is that what your understanding was?
Yes, sir.
Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
And you satisfied with how you've been represented?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea if you'd step over this way, please. Thank you. Yes.
Your humor last Monday broke the tension of a lot of us stressing over minor issues. It was very, very kind of you. Attention to humor was very kind.
Thank you, sir.
Judge, I have an Austin Vickery on the docket. Austin Vickery. Judge, we had sent this over to see if I could get Mr. Vickery here. He did not appear at pretrial.
State?
Capias, Your Honor.
No bond capias.
Kyle Vincent. He is present in the courtroom in Virginia. Judge, we've reached an agreement in Mr. Kyle Vincent's case, 24 CF 2189. The agreement calls for Mr. Vincent to enter a plea as charged. The agreement with the state is going to be negotiated down with departure. With the plea agreement?
Granted. To me that you believe the state could prove your guilt and you're not going to contest. To me that you believe the state could prove your guilt and you're not going to contest that.
Yes, Your Honor. Yes, Your Honor.
Do you understand by doing this you're waiving your right to a trial where the do you understand by doing this you're waiving your right to a trial where the state would be forced to prove your guilt?
Yes, Your Honor.
In this case, you'll be adjudicated guilty beyond 60 months of probation with special conditions of the evaluations that were discussed.
No.
Right, and then we'll move that. Yep. Judge, Mr. Watts is here in three case numbers, 24 CF 2325 and 24 CF 2326. We passed it over today for him to pay restitution. He's taking care of business. I think that the state's going to make an announcement in those two cases. That's going to leave him with one new case in which we're going to continue until 11/10.
All right, State?
Yes, Your Honor, in 2024 CF 2325, the state would announce a dismissal. I have a receipt here where he's paid the restitution in that case. And also in 24 CF 2326, I also have a receipt with the zero balance for restitution as well. So both case charges will be dismissed.
All right. Cases are null pros.
That's going to leave us with 25 CF 1651, in which I'll request a continuance until the 11/10 court date.
Very good. Thank you, Mr. Watts. We'll see you on the 10th. Stay in
Thanks,
touch
sir.
with Mr. McKinney, okay?
Come see me on this. Is there Keith Williams in the courtroom? I've received communication that he's going to be late. If we could call him at the end of the docket.
Sure.
And I'd also like to pass Justicia Willis, who's present in the courtroom, but I need to discuss a matter with the state.
All right.
And then Jason Willis is present in the courtroom.
Jason Willis.
Mr. Willis? Mr. Willis was in the hospital on pretrial.
Yes.
We passed it over today. He is present in the courtroom in 25 CF 985. This is a two-count information that I am going to be requesting a continuance. And I'm going to ask Mr. Willis to make an appointment to come see me at my office. While we're here, it may be appropriate to discuss the score sheet and offers from the state.
Judge, as charged, he scores 88.125 months with a maximum of 10 years. The state filed a two-count information. However, there were 3 failure to register charges at issue in this case.
All right. And
The posture of the case, I would need to complete one round of depositions prior to our next court date. But that's something that we should be able to schedule.
And so the maximum is the 10, he scores the 88 in months, correct?
As charged, Judge, yes. However, state's offer was to plead a guidelines on 1 count.
Which would be,
67.125 months.
okay. All right,
Thank you, Judge.
all right, it'll be continued 11/10. Is that offer going to stay open, State?
The state will leave that offer open, but we would ask that he be required as a condition of bond to meet with Mr.
All
McKinney
right.
before the next court date.
Get in touch with Mr. McKinney and have an appointment with him before our next court date, okay? Thank you, sir.
Judge, I have out in the gallery at the moment.
All right, and I think we've got Mr. Rivera, who is self-represented, is that correct?
Yes, Your Honor.
All right, you may approach.
Thank you.
Now, first, I know that you contacted my JA and asked that hearings be scheduled, but I also know that it's a little difficult sometimes for a self-represented to communicate with the state attorney's office. So ordinarily, I set those hearings in open court because the state will be present and we can coordinate them. That way it makes it easier for it to be done. So have your motions been filed?
Yes, Your Honor. This is 630 Rivera Pro Se. It's the state of Florida versus myself, 630 Rivera, the defendant on the 2022 CF 12-1214 and 2022 CF 1222. I did file the motion, as if I have it right here, on Monday the 8th, after we talked that, last week. So at this time, I'm just waiting for this motion to be set for hearing due to the gross negligence and misconduct from
Well,
the state.
right now, we're going to set the hearings. We're not going to hear them today because it's not appropriate to do
Yes,
so
Your Honor.
without them being set for hearing.
Understood.
And so the state, you had the benefit of the motion.
Your Honor, I have not. This is Ms. Bosso's case, and she should be back tomorrow.
And you say it was filed on the 8th?
I got it right here, Your Honor, if you would like to see, bailiff, if you don't mind passing this to the judge, that way he can see
Well, I'm
it.
just, I just am confirming that you filed them
Yes,
on the 8th.
This one is stamped as well, and also I do have the Florida bar answer that I was going to place with the motion, but I didn't. I do have it here. Ms. Bosso was CC on it as well. Oh, and one more thing that I wanted to inform you, Your Honor. The first district representative, Senator Gates, is aware of the situation, and he is been trying to file complaints against Ms. Bosso due to her.
Well, yes, sir, that's not relevant to anything that we're dealing with here today.
Yes.
You know, that's stuff
Understood.
outside of the purview of the court.
Understood.
So it looks like you did file the motion, but it appears like it was only filed in the one case.
On both cases.
Even though it has both case numbers, it looks like it's only in you see where I'm looking at, Madam Clerk? I'm looking at the 22 CF 1214. I see the case filed there, but it has the case number of the 22 CF 1222, but in the 22 CF 1222, I do not see the motion filed there at this point in time. So if you would please see to it that a copy of the motion is placed properly in the other progress docket. All right, so, and this is a motion to dismiss, it appears, state, so we will set this, Madam Clerk, our next miscellaneous date that's available.
October 16th.
October 16th at
Okay.
9 o'clock.
With that being said, we have the case scheduled for trial on the 22nd of this month.
Okay.
So we'll have to move days around, I believe. And also, you asked me to be here on Friday as well, the 19th.
All right, so state be prepared to hear the motion to that's right, because we are set for trial.
Yes.
All right, state be prepared to hear the motions on Friday.
Friday.
Judge, we would ask for more notice than that, given that this is the first we're aware of this motion, and Ms. Bosso will be handling the motion. I would like to give her time to issue subpoenas if need be.
Your Honor, Ms. Bosso has had this motion in her hands for multiple months already, so she has notice of this.
Well,
It says it was filed September 8th.
It was filed on September 8th. So tell me how she's had it for multiple months if it was filed on September
Because
the 8th.
the motion was filed filed while the case was still in Crestview before, and she was aware of the situation. The motion was never heard over there because once the judge was informed that he had to do what the bar stated, he recused himself from the case. And then they sent the case down here, and I had to resume.
You're going way beyond the question I asked. Was it filed in the case?
Yes, before.
When and where
In
was it
Crestview.
filed?
I will need to find the date, but it was filed prior to the 8th on Crestview when the case was still in the other court, Your Honor. It was filed. I have filed this since 2022 and 2023. I've been trying to dismiss these charges.
Okay. I need to know when it was filed.
Okay.
Because
I know I filed a motion.
Is that when you're saying January the 6th of 2025?
So I filed a motion based on what I have here, June, okay, give me a second, Your Honor, if you don't mind. On February 24 of 2023, over 2 years ago, Ms. Busseau responded to the motion I placed to dismiss charges, which was one of the motions I filed. She responded denying.
Okay.
Yeah.
Slow down, because let me catch up with you. It looks like, actually, I'm reviewing the progress docket now. It looks like the motion was filed
Excuse me.
July 24th, 2024.
That, Your Honor, there have been multiple versions of the motion, so you know. I understand that this last motion I submitted on September 8th, I believe it was submitted once before that. The previous ones were different to the ones we are looking at September 8th. But they were still motions to dismiss charges based on misconduct.
It seems that this version of the motion states a bit different grounds than your original motion.
Well, the previous judge told me when I filed the other motions, he was not happy, I guess, and he told me that those motions were not going to move forward because I wasn't citing the right rules. So I did some research and I found the information that I imprinted on the latest motion to dismiss charges. That's why this one has the rules and everything else. Okay. And it's different. That's the reason.
We'll hear the motion on the morning of jury review.
So that will be on the 19th or the 22nd?
The 19th.
19th motion.
And so, and on this case, how many jurors do we need for this case? And which case are we trying first, State?
Judge, I believe it's going to be the domestic violence strangulation case.
And that's the one. That's
1214.
the 1214 case.
Yes.
But I would defer to Ms. Basso. She will be here Friday.
All right, so we're going to call for 40 jurors.
That should be sufficient.
And we're going to say 2 days, including jury selection. All right. Now, you're here again with the case is set for trial.
Yes, Your Honor.
And you're here without a lawyer.
Yes, Your Honor.
And, you know, I'm going to have to ask you these questions
Yes, Your Honor.
not because I just like asking the questions and hearing myself talk, but because the rules require me every time you appear without a lawyer for me to ask you these questions. And do you understand that you're entitled to have a lawyer represent you? And if you can't afford a lawyer, one will be appointed to you at the state's expense.
Yes, Your Honor.
And I think last time we were here, you said that you don't believe you qualified because you had substantial assets.
That is correct, Your Honor.
And so you're choosing not to accept an appointed lawyer because you're choosing not to retain a lawyer.
I requested an attorney through the court for, what is it called, hybrid counsel.
Standby counsel.
Standby counsel, yes.
Right.
So that's when there was another attorney appointed prior to him, but his actions were also negative towards me. And then Mr. Williams was appointed, and.
But based upon what you told me last time, you wouldn't qualify for standby counsel at the state's expense because you don't qualify for the appointment of a lawyer.
Due to the amount of money, because I have already spent over $20,000 in private attorneys, then I brought that up to the court, and the court was like, wait, let's do something about it.
Oh, so you don't have assets anymore?
So I do have assets. I cannot do anything with my assets because I'm still married to the person who's doing this to me. Therefore, I don't have anything to play with. So the money that I had, the little money that I had, I hired 2 attorneys. I had to fire them due to their actions. Then I talked to the court appointed 2 attorneys because of their actions. Mr. Williams ended up being the second, which I requested to remove them last Monday, actually months ago, but last Monday was when it was actually
Right, and you
done.
discharged him on
So
Monday.
now, I am requesting to continue on my own.
Right. Okay, so you don't want standby counsel?
I do not
Okay.
want to stand
All
by
right, and so you understand the consequences, and basically, the rules apply to you like they would to a lawyer, even though you're not
Thank you
trained as a
for
lawyer.
that.
And, you know, and the other part of that is it's almost always a bad idea for someone to represent themselves.
Yes.
I think we went through that. I've had a couple of lawyers try to represent themselves, and they did a horrible job. Even though they knew the rules, even though they knew the law, they couldn't have that objective detachment of their own behavior, their own investment in the circumstances, and it became clear that they couldn't do what a lawyer could, which is have that objective detachment. So you understand that, right? That's
Yes,
one
Your
of the
Honor.
primary things. And
Yes, Your Honor.
you understand that although you would be questioning witnesses and dealing with the witnesses, the jury may, yes, sir, take your time, take your time.
I'm sorry, it's just, I'm listening, it's just.
I understand.
The pain.
Take your time.
Oh, my back. All right. Go ahead. Yeah, you are.
All right, and so you understand that all those things suggest that you really should have a lawyer represent you, but you've made the decision to consciously go forward without one.
Yes, Your Honor.
Okay, all right.
I got a question for you, Your
Yes.
Honor. Since you said that I'm here representing myself, and I should be, and I will be addressed as my own attorney, and I should behave as a court servant. May I ask you this, because I have to follow the rules.
Yes.
You know, and everything. So since I'm representing myself, may I ask you this? That way, it prevents, and this is in the courts, obviously, if the court permits. As you know, I am disabled. My disabilities are multiple. Sitting for prolonged periods of time, it causes issues. Standing, it causes issues. I am, according to the military, according to VA, I'm 70% mental disability for PTSD. So can I, when I come here in the morning, at least sign the document where the attorney signs? That way I don't have to be sitting here for hours, just exposing myself to the trauma of other people, you know, and seeing all this stuff and continuing enforcing.
We're not going to have to worry
disabilities.
about that because we only have 2 cases on the docket for Friday.
Yes.
At this point in time.
Just as in the event of the future, because today I was denied to do that, and therefore I was kept there, you know, in pain, when I could have, this could have been done in a few minutes and then schedule the appointment and go. You see? So I'm just asking the court to be cognizant of the situation and at least take some consideration into my disabilities. I'm not asking for any special favors. I'm just asking that, hey, my rights as a disabled person do not get violated or ignored or trampled. You know, people like me go to war to defend the Constitution, to defend our laws, for then come here and see that some of the court servants are violating the same rights that we go to fight for with blood, sweat, and tears, and sometimes our lives. So So, Your Honor, I do request that at least the court have some consideration. I know you do. I know you do, and I know you understand what I'm saying, and I appreciate everything.
All right, we'll see you
Thank you.
at 9 o'clock on the 19th. Be prepared to argue your motion.
Yes, Your Honor.
And be prepared also to consider the issue of jury instructions, which we'll deal with, and we'll decide on the 19th whether the case is going to be tried on the 22nd or on October the 6th.
Okay, and one more thing, the state does have all the evidence that will be presented on Friday.
Okay.
Thank you.
Thank you.
Have a blessed day, Your Honor.
All right. Mr. Durrell, you're back.
Yes, Your Honor.
What you got?
I do apologize. Ms. Dudley asked me to stand in for her.
Okay.
She said she believes she has a case on the docket. She thought she continued it at pretrial, but just to be sure, it is.
Well, right now, we got to just be sure, don't we?
Yeah, yes, Your Honor.
Does Ms. Dudley have a case on the docket, ma'am?
It is 4 case numbers, 19 CF, 14.
Who's the defendant?
I apologize, Your Honor. Nyrea Rudolph.
I don't think we have Rudolph, do we, Madam Clerk? Let's double check on the other docket. Give me one case number, please.
19 CF 1473 would be the oldest, Your Honor. It looks like the most recent is 25 CF 754.
It looks like it's set for 11:10.
11:10, perfect. Thank you, Your Honor.
Well, no, hold on. I'm showing on Odyssey that it is set for today.
September 10th, continued.
Okay, but, so that's the confusion. If she's looking at Odyssey, it shows that it is for today, but it was actually continued.
Okay, I will let her know. And that's all of the cases, Your Honor, just to be sure.
All right, thank you very much.
Thank you very much, Your Honor.
Now, who do we have left in the gallery here? Okay. Okay. Well, I'm going to take a short comfort break at this point in time, and we'll be right back. So we'll take 10 minutes. 10 minutes.
All right.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Wright Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Young Burt Reynolds or what? Am I looking good at there? Am I looking like a young Burt
For
Reynolds?
more than 70 years, the sweet aroma of the Crestview's Coney Island burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Island's burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
3 years now. CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com.
Nothing from you, thank you.
CQ Roofing, your hometown roofer.
Just found out this morning, she hired a project in Pensacola.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Knock low, bro. I'm Attorney Kool Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
That's just what my people in the office said.
Hey.
We're good friends.
Wait a minute. Are you in the CIA? 'Cause you have to tell that to me.
Yeah, I am.
I knew it.
I actually don't think I have to disclose anything.
Oh.
I
I don't know how the law
That's
works.
the worst spy rule I've ever heard. If anybody asks you, you have to say.
You have to.
Yes.
When you buy drugs, are you?
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Wright Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in the county. If you or anyone you know has been accused of a crime,
Nopes, you
give us
ready?
a call.
I am as ready as I'm going to be able to be at this point. So Judge, I've got Mr. Brewster.
I think he refused.
He refuses? Okay.
Is that right?
So Judge, we left this set to see if the orders of appointments for me had been entered, and I think they have been. So,
Am I right, bailiff? Mr. Brewster, he's not with us.
Number 4, yes, Stephen Brewster, I have refused written down on that sheet. Yes, sir. That's me.
so I think where we had been was that there had been another evaluation by someone with DCF or somewhere. And I think the court was going to consider how to resolve whether or not he was competent. That was the plan for today, but now that he's refused, I don't know where we are.
Yeah. I don't think we can, excuse me.
So do you want to set it for a competency here?
Do we have to do that if we're both stipulating that to the report?
Well, please approach.
We can help.
Back Home Bakery Cafe is 2 blocks. Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m.
In 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call call coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
All right.
Judge, I then have Susan McFarland. Judge, she's present. Judge, I believe the state's victim advocate spoke with the alleged victim, and they're supposed to be sending me a new address so that we can reschedule the victim's depot. She lives in South Carolina.
Right. State.
So we need to continue it, Judge.
We have no objection, and I'm also going to, we spoke with the victim's daughter. We're also going to provide you with her email address as well, so you can hopefully serve it a couple different ways.
Okay.
All right. So 11:10, stay in touch with Mr. Nopes. See you then. Okay?
What day, sir?
The 10th of November.
10th of November, yes.
Thank you now.
Judge, I then have Paul McKenna. Judge, can we just pass this for a few minutes? He had stepped out, and by the time he
Sure,
went
you
back-
just need to chat with him on the final?
Yeah.
Okay, very good.
I think
Just
we
call,
can interloop.
you, as soon as we're finished with your road cases, you can chat with him and bring it back up.
Yes, sir. Sit down for a minute and talk. Judge, then I've got the Nicole Medecki. Judge, she needs to, state made an offer and she needs to come and sit down and talk to me in my office, or actually by telephone, either way, but she's not ready to proceed at this point. We need to consider what the state's offer is. And she got a new case in also.
All right.
No objection from the state.
All right, it'll be continued to 11:10. You said new case, is it not, is it another case that we have, Mr. Nopes? You got the case number so we can pull them all together?
Judge, it's on the docket today, 25 CF 688.
Okay, right, and last time we were here, you were indicating you didn't yet have discovery on that case and you're waiting for a global offer on everything, right?
Judge, the state did make a global offer, but I don't know that I've gotten the discovery yet.
Okay. All right, so we'll continue to 11:10, and if you end up with a good offer you feel like you take, you can advance at any time for a plea, okay?
Yes, sir.
All right.
Judge, then I've got Cody Owens, 25. Actually, she's an inmate. You want to do her? You got her? Huh? Sure.
Well, then I show Brian Petit.
Brian Petit is here, Judge. Judge, he has rescheduled an appointment to meet with me in Crestview on September 30th. In this new case, this extortion case, I need to set depositions on, Judge. And he also needs to meet with me as well.
All right. State?
No objection to continuance to November 10th.
All right, 11:10 it is. And be sure you keep that appointment with Mr. Nope so he can chat with you about everything that's going on, okay? Yes, sir. All right, thank you now.
See you soon. Judge, I then have Mr. Panetta Lima. Judge, I'm going to need an interpreter for Mr. Panetta.
All right. We'll call up the interpreter.
And then I think I have Jared Smith. So Judge, the state and I have discussed options in this case, and the bottom line is I think my client wishes to go to trial the second week of your trial week, which is the October 6th week, Judge. The first 3 days I'm available of that.
We can set the case for VOP evidentiary hearing the first week, and then we'll have the trial the second week. That would be ideal for the state.
Judge, the first week I'm already scheduled to be out of town.
All right. So how are we going to handle that then? We'll just queue up the VOP first, and then
let me grab my calendar. Judge, I'm scheduled to be gone Wednesday the 24th, 25th, 26th, and I'll be back in the office on the 29th.
Well, how about we set the VOP for, let me just, sorry. I'm checking with Miss Natali. I'm thinking we'd do it the afternoon of the 1st, after pretrial detentions. So when are you back, you said?
Judge, I get back, but I'll be in the office on the 29th.
Okay, so the afternoon of the 1st, we could do it?
Afternoon of October 1st.
Yeah, we just schedule it at 2:30.
That should be fine, Judge.
All right, so we'll do the VOP evidentiary at 2:30 on 10/1.
October 1st at 2:30, VOP here.
Correct. And trial, trial week of 10/6. And how many jurors do you think we need?
I think the standard amount would be appropriate.
Judge, I don't think it'll be a very long case.
All right, so 1 day plus jury selection?
Yes, sir.
All right. All right.
Okay, Judge.
All right, anything else?
I believe that's where we're at, Judge. We're going to still try to resolve the matter, but at this point, the state's not willing to budge.
Okay, all right, we'll see you then. Yeah, and do you think we need jury review on Friday? Go ahead and set it for jury review at 9 o'clock on Friday morning, the 19th. Superpower miscalling dates.
That'll be fine.
19th, 9 o'clock on the 19th. And that way we'll Rochambeau all the dates and everything, be sure everything's still the working pieces.
Eli Lima.
Raise your right hand, Madam Interpreter. You swear to interpret these proceedings truthfully, adding nothing and subtracting nothing.
So, Judge, the state and I have agreed to continue this matter. I believe I need all of discovery, I think, but in the offer, I need to go talk to my client about it. So we need to continue it.
State?
No objection. We'll make sure to get that over to Mr. Knapp.
I think it's 11/12.
11/12, yes. And so when we were here last, we were talking about the pending federal case, but that's been resolved.
That's
I
correct.
believe
I think
it
we're going
has.
to be looking at trying to resolve this with some sort of concurrent sentence is the goal.
Okay. So he's here having been released from the federal case for the disposition of this case.
Correct.
Okay. So whatever we do after the disposition, he'll be returned to the federal custody is our idea.
That's how I understand it.
Okay. All right, very good. So we'll reset this 11:12, and of course, if you do have a result after you have the opportunity to speak to him, Mr. Nopes, you can advance it.
Yes, sir.
Cody always would be next.
Yes.
Cody always would be next.
Yes.
Cody always.
So Judge, on Ms. Owens' case, the state's standing tall on their, on the trafficking charge. So the state and I have agreed to continue. I need to set the depots.
No objection from the state, Your Honor.
All right, it will be continued at 11:12.
Yes, sir. Thank you. So Judge, I think I need to speak to Mr. McKenna, Judge, so I'll be right back.
All right, Mr. Morris?
Thank you, Judge. Good afternoon, how are you?
Good, sir.
Excellent. Daniel Uzziah Solless. Mr. Solless, President, approaching the lectern. If I may approach.
Granted.
Thank you. The forfeiting of the items that were seized are specifically related to that Okaloosa County Sheriff's Office case.
And based upon a couple of recent DCA cases, I'm asking everybody on this forfeiture, does anyone claim that you believe the state could prove your guilt, that you believe the state could prove your guilt? Do you understand that?
Yes, Your Honor.
All right. Got to make a free and voluntary decision. Do you understand that?
Yes, Your Honor.
All right. And this is not a challenge to your plea, but part of my job is you've got to make a free and voluntary decision, and that requires that you know and understand what you're doing. So that's the reason for the questions, because I see the question mark on your face for me asking these, okay? Because we've had this before. Someone goes to work, someone goes to work, and part of their job is they have to have access. You say freely and voluntarily entered into and will accept the plea. And probation will give you some instructions before you leave.
Do you have an extra?
Are you satisfied with what he's done for you?
I am, yes.
The court will find the plea to be freely. Are you satisfied with what he's done for you?
I am, yes.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. And probation will give you some instructions before you leave.
Does he need to go? Brandon Marshall, Stephen Poindexter, waivers in Mr. Poindexter's court file. Judge, Mr. Poindexter is a Texas resident. He was not able to secure transportation from last week to today, so I'm going to be asking to continue his matter one cycle and anticipate a resolution.
Because we were looking at the PTI.
Yes,
I had it just for status today anyhow.
Okay, excellent.
So we'll do PTI status for the next cycle. Is that right, State?
That's correct, Your Honor.
I had it just. We'll do PTI status for the next cycle. Is that right? 10. All right, thank you.
Judge, Judge.
Safe journey home.
Thank you very much.
All right, good day.
May I recall my case?
Yes,
This would be Brent Whitner, 24 CF 2028. He also has Mr. McKinney on another case.
correct.
That's 25 CF 629. Posture of the case is, on Friday, we did reach a pay and dismiss on my case. And I believe there's going to be some sort of reinstated PTI on RCC side. I'm unsure where Mr. Whitner is at this point. It's unlike him to not show up in court. So I'll defer to the state whether or not we're going to issue a capias or whether or not we're going to continue this to try to get it done.
This is a situation, though, where he's had numerous contacts with you, right?
Oh, a lot.
So let's see if we can get it resolved. I'd rather do that than.
Procedurally, if we could continue it, and then that's something that's going to come back on the docket immediately because we've got a resolution to both cases.
All right, very good. And so we'll continue the full cycle, but if you get in touch and can work it out, bring it on in.
I'm going to try to do that by this week, Judge, but
Okay.
yes, we'll do that.
Anything else for you, Mr. Harper? That's it?
No, Your Honor, just the court dates.
11/10.
11:10.
Thank you, Judge, that's all I have.
All right, thank you. All right.
Judge, I have a matter I can call out of the gallery.
All right, please do.
That would be Keith Williams.
Williams, please.
And Judge, he has some mobility issues. Might take him a minute to get up here.
Okay, absolutely.
I don't want him to rush and fall down.
Absolutely not. You want a chair to sit in while you're up here, sir?
Standing is okay.
Okay, sir.
Just get to the podium.
Yes, sir.
Judge, we passed 24 CF 2769 over to the day from pretrial. I've been in communication with Mr. Williams. He's had to reschedule a meeting with Dr. McDonald's office for a confidential mitigation evaluation that is currently reset for October 16th. We have had to reset depositions of 2 of the Fort Walton Beach officers in this matter. Those 2 things are the last 2 things we need to really do to bring this case in. I do think it's going to end up in a agreed upon disposition rather than a contested jury trial. But today I would request a continuance until the November 10th date.
All right, State, are the depots set? You said FWBPD?
Yes, Judge, we have a date in October set. I don't have that date.
16th for the doctor.
The 16th for the doctor. It's another date. I think it might be the 20th for the law.
But they are set?
They are set, Judge.
Okay, all right. State continuance agreeable?
Yes, sir.
Okay, it'll be continued 11:10. Now, stay in touch with Mr. McKinney, and you've heard you got that appointment, make that appointment too, okay? All right, that'll be it.
And we have a client meeting, Judge, to review all the discovery on Wednesday.
Okay.
So he's coming in, and we should be ready on all that when we come back.
All right, very good. All right, thank you, that's all. Okay. Good day, sir. All right, Mr. Koch, you got some more we can take care of while Mr. Nopes is negotiating?
Absolutely, Judge. Mr. Derek Smith and 25 CF 561.
Derek Smith.
Yes, Your Honor. The count 1 is going to be a lesser included misdemeanor possession of drug paraphernalia. Florida Statute 893.147, subsection 1. I have a signed plea form by all parties to the misdemeanor. 2 misdemeanor counts, adjudication of guilt, credit for time served, 270 court costs, 150 defense. If I may approach the sign.
Granted.
And if I may recall, Miss Melissa Sloan,
Sloan, please.
25 CF 307. Okay. May just have a brief moment, Judge.
Yes.
Judge, my client will enter a plea this morning. Speaking with Mr. Snell, he has no objection to set off sentencing to October 16th at 9 a.m.
And you've discussed with your client that if I defer sentencing, that this is an open plea to the court?
Absolutely.
And if she fails to appear, or if she gets new charges between now and then she faces the full range of sentencing, not just the agreed-upon sentence?
Absolutely, Judge. This would be if any hiccups and if she doesn't come for that October 16th, it will be a minimum of that 3 years, maximum 37 years. And my client knows that this court can, anything in between. So she's fully aware, Your Honor. If I can announce the terms, ultimately, count 1 will be no prost. Counts 2 and counts 3, adjudication of guilt. There's a 3 years Department of Correction, credit for time served, court costs, defense costs, and there's that $50,000 fine. Counts 4 and counts 5 will be adjudication of guilt, credit for time served. All counts to run concurrent. I did indicate on the plea form, set off sentencing to October 16th, 2025 at 9 a.m. If I may present the signed plea form, and my understanding, I'll keep the score sheet for that October 16th.
Granted. All right, your client need a moment, Mr. Koch? All right, raise your right hand. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. Now, you heard what Mr. Koch said, and you signed the written plea form.
Yes, sir.
How old are you?
51.
How much school do you have?
From college?
All right, you able to read and understand the plea form?
Yes, sir.
All right, did you do that before you signed it?
Yes, sir.
All right. According to this plea form, you're pleading no contest to the announced charges. Do you understand that?
Yes, sir.
And that tells me that you believe the state could prove your guilt to the jury and you're not going to contest that.
Yes, sir.
Do you understand by making this plea, you're waiving your right to a trial by jury,
Yes.
where the state would have to make that proof?
Yes, sir.
All right. Now, this is a plea with a deferred sentence, which means that we're going to come back for sentencing on the 16th of October at 9 a.m.
Yes, sir.
If you appear as scheduled and you have no additional law violations, then the agreement is that the state will null pros count 1, and you will be sentenced on count 2 to 3 years in the Department of Corrections credit for all time served with the fees, costs, and fines announced. Count 4 and 5 were credit for time served, and they'll all run concurrent. Now, if you do not appear, or you get additional charges, is the state intending to keep count 1 outstanding, or is count 1 still going to be null pros?
That's correct, yes, sir. Count 1 is no process, yes. It will remain that way.
Yes, sir, that's correct. I gave you an either or. Is it null pros or is it not null pros, regardless of what happens on the deferred sentencing?
That's correct.
It is null pros regardless?
Yes, sir.
Okay. All right, so if you fail, then it's an open plea to the court on counts 2 and 3. And so you're facing a maximum of 36, 37 years in state prison if you fail to appear, if you get new charges. Do you understand?
Yes, sir.
As Mr. Koch, now, we're set for trial next week. And you told me this morning that you wanted to get a new lawyer, and I said, well, you can have a new lawyer if you want. That's up to you, but it's still set for trial because you announced ready for trial. So now you're accepting the plea. Why are you making the decision to take the plea now versus going ahead and go to trial when you've demanded your trial and we set it for trial?
I don't have enough time for an attorney.
Okay, well, we have, I think on 7/14 when we were here, the reports were received, the depositions were done. I indicated if it was continued, that it would be continued for a plea or trial. And then we came back on the 8th, and it was indicated it was plea or trial. And we said what we would do with the amount of time to try the case. And then it was today you came and said that you wanted to get a new lawyer. So I don't understand why you're saying you didn't have enough time.
No, I mean, for now in a trial. There's not enough time for a lawyer.
Right, well, right, because just getting a new lawyer after the case is announced for trial is not a reason for a continuance. And so if you're telling me the only reason you're taking this plea is because you wouldn't get a continuance to get the new lawyer, then I'm not going to accept the plea. We'll just go to trial.
There's not enough time for now, between now and the trial, to get a good lawyer to represent me. And we just got the money to get the lawyer, so that's why it's taken so long.
Okay, do you want to offer this plea or not?
Yeah,
Okay, do you believe resolving the case this way is in your best interest?
yeah.
All right, the court will find the plea to be freely and voluntarily entered into and will accept the plea. And we'll set it for sentencing on 10/16.
Yes, Judge. That's all I had out of custody, Judge.
Judge, I have one more.
All right, And then we're just going to queue our inmates up and just roll them, okay?
Judge, this is Desharia Willis. Ms. Willis is here in 25 CF 663. We have reached an agreement for a plea to a misdemeanor criminal mischief. Madam Clerk, that is 806-13 sub 1 sub B 2. The agreement calls for a withhold of adjudication, 6 months of JCS probation. Special conditions include an anger management course, $270 in court cost, $150 cost of defense, standard JCS cost of supervision. May I approach with the misdemeanor?
Granted. Raise your, so you understand your plea adjudication will be withheld, and you're going to be on 6 months of probation with the special conditions that were announced, including the fees and costs and the cost of supervision. Is that what you understood?
Yes, sir.
All right. The court will find, and Mr. McKinney answered all your questions about the plea and how it affects. And you voluntarily entered into and accept the plea with the withhold at this time. Thank you.
Thank you, Judge.
Thank you now, ma'am. Good day.
Timothy McKeown.
And we're just going to roll down. Do you have anybody else out of custody, Mr. Nopes?
I do, Judge. Paul McKinney.
Okay. We'll do the out of custodies, and we're just going to line up the inmates to get them out as fast as possible. Is McKinney out of custody?
He's right here, Judge.
Okay, good.
Mr. Hack, can I get a picture of you?
Judge, may I approach?
Granted.
Judge, the defendant, Paul McKinney, has entered a plea in 24 CF 1601 as charged with the understanding that he'd be adjudicated guilty, placed on probation for 5 years, have no drugs or alcohol while on probation. Conditions of probation are that he would apply for 3 jobs per week and show proof thereof. And while he's on probation, he would also make at least $100 a month toward restitution to Wells Fargo. Restitution is set at $3,166.83. He'd be required to pay $515 in court costs and $150 in court-appointed legal assistance fee. He can terminate the probation at the 24-month mark, provided he has not violated his probation and he's met all the conditions thereof.
State. Raise your right hand, please, Mr. McKinney. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay. And you can put your hand down. You heard what Mr. Nope said, and you signed the written plea form?
Yes, sir.
How old are you?
37.
How much education do you have?
High school.
All right. You able to read and understand the plea form?
Yep.
Did you do that before you signed it?
Yes, sir.
And is what you read in the plea form what Mr. Nope's just announced to me?
Yes, sir.
Do you understand that you're pleading no contest to the announced charges?
Yes, sir.
And that tells me that you believe the state could prove your guilt on these charges and you're not going to contest it.
Yeah.
Okay. There was some hesitation there. Do you disagree with that?
I'm not in the shape to disagree right now.
What? Okay. What's going on?
It's fine.
Well, when somebody says they're not in shape to disagree, it makes me concerned whether or not you feel you're making a free and voluntary decision.
For my scenario, it's the best fit answer. I'm all right. I'll do the probation and pay the money.
Okay, so let me see if I can restate. Based upon everything that's going on for you right now, you believe accepting this, making this plea to the court is the best outcome for you, notwithstanding your feelings about the case and whether you might prevail at trial?
Yes, sir.
Okay. Do you understand by making the plea, you are waiving your right to a trial where the state would have to prove your guilt?
Yes, sir.
Okay. You'll be adjudicated guilty beyond the 5 years of probation with the no substances and the other conditions, including the restitution. You can terminate your probation at 24 months if you've completed all the conditions, including paying the restitution. Is that the offer you're making to the court?
Yes, sir.
Mr. Nope's answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how he's represented you?
Yes, sir, every bit of it.
All right. The court will find the plea to be freely and voluntarily entered into and accept the plea. Now, I mean, I just want to be sure, are you okay? You understand what's going on? You okay today? What's going on, Mr. McKenna? Because you're answering my questions, but you're really looking down and you're not engaged, and I'm worried that you don't really understand what's going on.
I'm not sure about my Marchman Act situation or my federal situation. There's a lot on the subject. I'm just gonna sign for probation and knock it out.
Okay. So you're currently on federal probation?
Not even close. Just a lot of, I really can't speak on what I'm not sure of.
Okay. Are you facing federal charges? Or are you just concerned
Or
about it?
like I don't want to talk about that here. It's up and down with a lot of different subjects. I got a lot of honesty out of a few people and a lot of dishonesty out of a lot more.
Okay.
But it's fine.
Okay.
Separate matters.
All right. You know and understand what's going on today, though?
Yeah.
You just have these other things on your mind that's worrying you?
Yep.
Okay, because I've just noticed, and once again, you've heard me say it a bunch of times today, my job is to be sure you're making a free and voluntary decision. I can only do that if you know and understand what's going on. And so sometimes people don't know and understand what's going on, and sometimes they're just kind of overwhelmed by having to make the decision. Is it fair to say you're overwhelmed by having to make this decision and worried about its consequences on you? Is that what's going on? Or is there something else I need to know about?
If I knew more, I could tell you more, and respectfully, I'm all right with this situation right now.
Okay, all right. All right, the court will find the plea to be freely and voluntarily entered into and accept the plea. If you'll step over this way, please, sir.
Thank you, Judge. I believe that's all I've got.
All right, and so now we'll call our in custody just in order they're there. What's that?
In custody. McKenna?
Morning, Your Honor. Mr. Timothy Mcuin, case number 25 CF 112. This is going to be a plea this morning, Your Honor. In exchange for the plea of no contest, the state has agreed to dismiss counts 1 and 3. On count 2, which is going to be an adjudication of guilt, 24 months, Department of Corrections, cost of prosecution, cost of defense. And count 4 is going to be adjudicate and credit time served. If I may approach, I have the signed plea form and the score sheet.
Granted.
Your Honor, this is a downward departure for the purposes of a legitimate and unopposed plea.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Cochran said on your behalf and signed the written plea form.
Yes, sir.
How old are you?
57.
And how much education do you have?
GED.
You able to read and understand the plea form? Did you do that before you signed it?
Yes, sir.
And is what you read what Mr. Cochran just announced to me?
2 years DOC and credit for all time served?
Yes, sir.
Yes, sir.
And do you understand you're pleading no contest to the charges?
Yes, sir.
And that tells me you believe that on the counts you're pleading to, the state could prove your guilt and you're not going to contest that.
Yes, sir.
And by doing this, you're waiving your right to a trial by jury where the state would have to prove your guilt.
Yes, sir.
And as you said, it's 2 years in Department of Corrections with the fees and costs and credit for time served. And those fees and costs will be, Madam Clerk?
$615.
$615 plus $150 state-provided legal assistance. And Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
You're satisfied with how he's represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea if you step over this way, please, sir.
Manuel Mejia Garcia is next.
Your Honor, I discussed the plea offer with my client. At this time, he's not willing to accept the offer as it stands. I would ask to set this for 11:10.
And this is 24 CF 630, is that right?
Yes, Your Honor.
All right, is the offer going to stay open, or is the state withdrawing the offer?
The state will leave the offer open at this time. I'm still undergoing negotiations with Mr. Cochran.
All right, what else needs to be done to have this case ready for trial?
I honestly, Your Honor, I don't have it. Honestly, Your Honor, I don't have an answer for that right now.
The only reason I'm asking, I'm just looking at the filing date and the number of continuances, and I just want to be sure that we're focused on that. Now, you may have a resolution, but I want to be sure everything's done and ready to get the case tried, if possible, before we hit the 2-year mark.
Yes, Your Honor, I'll review it. If there's anything that needs to be done between now and the November court date, I'll make sure it is at least scheduled by the time we're here for the next date.
And if need be, so we be sure that the file's documented, you can submit to me a scheduling order. That way it'll be in the court file and
Okay.
ready to get the case tried, if possible.
Your Honor, if we can bring him back out in a few minutes. He wants to address the court. He did provide a letter to the interpreter that's in Spanish, so I'm going to ask her to let me know what's in it before I advise him whether or not to advise.
All right, please hold the defendant until we have the opportunity to have the interpreter review that, and we'll call him back.
Yes, Judge.
Thank you, Your Honor.
Raul Mila is next.
Good afternoon, Your Honor. We have Mr. Raul Mila. He's here on 4 cases. I'm going to ask to set this for 11:10. I have to go back over and look. I believe the depots have been completed. We are still in negotiations. My client has, given me some counters to give to the state. I'm pretty aware what the state's position is, but I will still present my negotiations to them.
All right, so my notes indicate that the current offer is 25 years Department of Corrections with the fees and costs, no supervision to follow. Is that right?
That's correct, Your Honor.
And does the state anticipate that they're going to deviate from that plea? Mr. Cochran has to zealously represent his client and convey any offers his client's made. But you know this court's position. I like to have an open discourse in open court where everybody can hear and understand, and I can make notes. What's it going to take what will Mr. Cochran have to present to you for you to deviate from that?
There is nothing absent exculpatory evidence on every case. And there's multiple cases with very serious charges. There's nothing absent some sort of exculpatory evidence on every case that would get us to deviate from the 25-year Department of Corrections offer.
And that 25 years is for every one of the cases, correct?
Yes, sir.
It's a global offer to resolve all of them.
Correct, Your Honor.
And what is the defendant's maximum exposure on all 4 cases?
It's life, Your Honor.
All right, and so your agreement on the 25 years, is that a departure based upon a negotiated plea?
It wouldn't be a departure, Your Honor. It would be within the guidelines. Just the exposure would be up to life.
Okay. Right, and so you understand, Ms. Mia, the reason I'm doing all of this is because your cases are, one of them is already 2 years old. The rest of them will be 2 years old by the time we get to the next trial cycle. It's my intention not to continue them anymore after that. So I want to be clear what the plea offers are and what it would take for the state to depart from those plea offers. Because I make notes, and that's kind of been where the state's been the whole time on these offers. So when I see that, it says to me the state is pretty firm, and that's the reason I'm sort of twisting their arm. What's it going to take to change? And they're basically saying it's going to take some substantial, undisclosed evidence right now that would challenge their view of the case for them to change the offer. So I'm not taking a position on that, but I think you need to understand where they're coming from and hear it directly from their mouth, right? So you can understand what the potential outcome is. Now, your offer of the 25 is going to stay open through the next trial schedule? I mean, the next cycle?
Yes, Your Honor, it will.
Now, everything done to try the case? Which one would we try next cycle if it's not resolved?
23 CF 150.
1501 will be tried next cycle absent a voluntary resolution?
Yes, Your Honor.
And that's because it's the oldest, or what's your reasoning?
It's the oldest, but from our perspective, it's the one that we feel the most confident on.
All right. All right. Any Mr. Cochran, any questions based upon the court kind of giving the state a hard time there?
No, Your Honor. I have a Spanish plea form. So I took the electronic copy of that document and I translated it through via Google Translate document. I have a Spanish plea form. So I took the electronic.
in reading the plea form by providing a Google Translate version of the document. In reading the plea form by providing a Google Translate version of the document. And is what you read in that version what was announced just now? All right. Do you need any more time with the interpreter to go over the document? Or are you satisfied that what you've read is what we've just heard Ms. Cochran say?
Yes, I'm satisfied.
All right. Do you, how old are you? How much education do you have, formal education?
Just common cycle, basic education, and at 18 I was enlisted in my country in the military.
All right. Were you able to read and understand the translated version of the plea agreement? Do you understand by this plea arrangement that you're pleading no contest to the announced charges? The plea to be freely and voluntarily entered into and accept the plea. Thank you.
One moment here. We attempted negotiations, and right now we're not able to resolve it. We attempted negotiations, and right now we're not able to resolve it. I need to go to the jail and see my client.
All right. All right. All right. I see we had depots for the investigator have been reset a couple of times. Were we able to successfully get the depot done?
The only that has been done at this is an FDLE depot. Other depots, and we did our motion to suppress hearing already. Other depots, and we did our motion to suppress hearing already.
Okay. And once the FDLE depot's done, you'll be ready for trial?
Yes, Your Honor.
Okay. State?
No objection.
And Mr. Mosley, so you understand, the reason I'm looking at that is because at the next trial cycle, your case will be 2 years old. So I want to be sure to move the case up to a conclusion since it's 2 years old. That's the reason I'm kind of pushing on these questions, okay? Okay. All right. And is there an offer at this point in time?
Yes, Your Honor, it is a 7-year offer, which would be the 7-year minimum mandatory sentence.
No supervision to follow?
No supervision to follow.
All right. And does that include a mandatory fine?
Yes, Your Honor.
And how much is that fine?
$50,000.
All right. Anything else?
That'll be it, Your Honor.
All right. And is that a departure, or is that?
It's a guideline sentence.
That's a guideline sentence? All right. All right. Does the state agree to the continuance at this time?
We do, Your Honor.
All right. It'll be continued to 11/12.
Terry Price.
Judge, this is Mr. Terry Price. We're here on two cases, 24 CF 1926 and 25 CF 254. Yes, Your Honor. This was set for plea or continuance. It was a three-year probation offer with a withhold adjudication, Your Honor. At this time, my client wants to continue these cases to 11/12. Specifically in that 24 CF case, there's surveillance videos from the Family Dollar we still need to receive, and my client wants to look at those surveillance videos. Other than that, potentially a depo on the civilian, Mr. Higgins, in that 24 case, but other than that, that would be ready next cycle, Judge.
Depo of Mr. Higgins?
Potentially, once we see those videos.
Is he from the Family Dollar?
Correct, Judge.
Solution.
Correct, Judge.
Okay. For the 25 and the 24 case?
That's correct, the global.
All right. And the state going to leave that offer open?
Yes, Your Honor.
Okay. 11/12 at this point in time.
David Roberts on your next.
Maggie, we'll have a hearing date for that. Yep, thank you, Mr. Price.
Mr. Roberts.
Mr. David. Judge, this is Mr. David Roberts, 24 CF 2086. If I may have a brief moment.
Yes, sir.
Count 3, adjudication of guilt, 5-year sex offender probation with sex offender designation, no contact with minors, forfeit seized devices, no internet or internet-capable devices, GPS monitoring at $1 a day, curfew from 10 p.m. to 6 a.m., adjustable by probations for work or school purposes, court costs, $150 in defense costs. Now run consecutive to count 1. Count 4, adjudication of guilt, 2 years sex offender probation with sex offender designation, no contact with minors, forfeit the seized devices, no internet or internet-capable devices, GPS monitoring at $1 a day, curfew from 10 p.m. to 6 a.m., adjustable by probation for work or school purposes, and that'll be consecutive to count 1 and count 3. Ultimately, Your Honor, this is a 3-year Department of Corrections, followed by a total of 7 years sex offender probation. If I may approach with the signed plea form and score sheet.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Okay. You can put your hand down. You heard what Mr. Koch said on your behalf and signed the written plea form?
Yes.
How old are you? How old are you?
38.
How much education do you have?
High school.
All right. You able to read and understand the plea form?
I do.
And did you do that before you signed it?
Yes, sir.
Just a second. And did you read it and understand it before you signed it?
I do understand.
Yeah. And is what you read in the form what Mr. Koch just announced to me?
Yes, sir.
All right. You understand you're pleading no contest to these charges?
Yes, sir.
And that says to me you believe the state could prove your guilt and you're not going to contest it.
Right.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Okay.
Do you understand that? All right. And you're going to have 5 years of probation with the announced conditions, including no contact with minors, no internet or internet-capable devices, the GPS monitoring, and the sex offender designation. Do you understand that?
Yes.
Do you understand the designation will affect where you can work, where you can live, and who you can be around? Do you understand that? All right. Mr. Koch answered all your questions about the plea and how it affects you.
Oh, yes, sir.
He has answered all your questions. And are you satisfied with how he's represented you?
Sure.
Say again?
Yes.
Okay. The court will find the plea to be freely and voluntarily entered into and will accept the plea with the adjudication. If you'll step over this way, please.
Adjudication?
Yes.
Sorry. Witnesses. Next will be David Stevens.
All right.
Judges, Mr. Stevens, we have 4 case numbers, 24 CF 2740, 24 CF 2743, 24 CF 2744, 24 CF 2778, Your Honor. Judge, yes, this was set for plea or continuance. We are still in active plea negotiations with the state. I provided my counter last time I was in court, basically the 1 year county time, followed by 5 years drug offender probation. We are still seeking inpatient programs. I'm still waiting to hear back from Keaton. So I'd like to continue this to the 11-12, but this is still very active negotiations. And just to follow up from last time, that 24 CF 2740, this is where the AV, we had no contact, we tried to depose, so that, of course, that helped our position for negotiations.
All right. Does the state agree to a continuance?
Yes, sir. We are negotiating. Our position has been the same. However, if he is qualifying for treatment, we want to see what the outcome of that is. So yes, we agree.
All right. All right, so we'll continue the case to 11-12, and of course, if you work it out sooner, you can advance it for a plea anytime.
Absolutely. Thank you,
Okay.
Judge.
All right, thank you. Mr. Nopes, I show you just have Zimmerman. Is that right? Natalie Grace Zimmerman. I don't show that she is incarcerated, though.
Judge, she is not. I think my office was not able to get a hold of her to get her here today. So we continue.
All right, state have any objection to the continuance on Zimmerman?
No objection, Your Honor.
All right, so we'll continue at one cycle.
Okay, so 11-10?
Yes, sir.
Thank you, Judge.
Matthew Sweeney.
And that's all from Mr. Nopes, right, Madam Clerk?
Yes, Your Honor.
Okay, all good. Sweeney.
Judge, this is Mr. Matthew Sweeney, 2 case numbers, 25 CF 215, 25 CF 1518. If I may have a brief moment.
Granted.
Thank you, Judge. This is going to be a change of plea this afternoon. It will be adjudication of guilt, 3 years of standard probation, $40 per month cost of supervision. Court costs, $2,106, $250 in defense costs, 1 year driver's license revocation. There's 50 community service hours, maintain gainful employment, or submit 3 job applications per week, no drugs without a valid prescription, and random UAs. There's going to be a suspended sentence of 4 years in Department of Corrections. All counts and cases to run concurrent. And I have 2 matters, if I may just briefly address, that aren't on this plea form, but regards to probation. My client operates his own tree service business. Of course, per the maintain gainful employment or submit 3 job applications per week. Is there a way he can, or how would the court want us to handle that?
I'm sorry, say that again?
He owns and operates his own tree service business. In terms of is maintain gainful employment or submit 3 job applications per week.
Well, if he owns a business, then he needs lawful employment. He needs to provide his business license.
Okay.
And he'll need to provide proof of working.
Okay.
Invoices and things like that, just to show he's working a minimum of 30 hours a week. We have an incentive for people who work 30 hours a week over a 6-month period. So he needs to just provide his business license and then invoices and just show that he is actively working.
Okay, excellent. Did that satisfy? Okay. You have to check it today. Here in Okaloosa. And then lastly, the 50 hours community service. Is there an option to buy that out? Okay. And Mr. Snell indicated, Your Honors, for the record, that there is no objection to buy out those 50 hours. If I may approach with a signed plea form, and Mr. Snell will follow this up with his score sheet later today.
Granted. But the sentence imposed is a guideline sentence, or is it a downward departure, or?
It's going to be really close.
It's going to be a downward departure, Judge.
It's going to be just above it.
Okay, so it is.
It's a negotiated,
Okay.
uncoerced plea.
Uncoerced negotiated
Yes.
plea with a departure. Okay. All right. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. You heard what Mr. Koch said. You signed the written plea form.
Yes, sir.
How old are you?
I'm 44 years old.
And how much education do you have?
I graduated high school.
All right. You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read in the plea form what Mr. Koch just announced to me?
Yes, sir.
And do you understand that you're pleading no contest to the announced charges?
Yes, sir.
And that says to me you believe the state can prove your guilt and you're not going to contest it.
Yes, sir.
And do you understand by doing this that you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
You'll be adjudicated guilty beyond 3 years of probation with the fees, costs, and other conditions which were announced, including the driver's license revocation. We've discussed your gainful employment, which probation will explain to you if you're self-employed what you need to do in that regard. Now, there's a 4-year DOC suspended sentence. Do you understand what that means?
Yes, sir. If I violate, I go to prison for 4 years.
Correct. And so that it's going to be up to you. That violation means that the sentence will be imposed.
Yes, sir.
Okay. And I just explained that because some people don't understand. I want to be sure you do.
Yes, sir.
All right. With that, has Mr. Koch answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how he's represented you?
Absolutely.
The court finds the plea to be freely and voluntarily entered into and accepts the plea. Thank you.
Thanks, Judge. You're welcome.
Paul?
Good afternoon, Judge. Jason McKenna on behalf of Shaquem Hall. He's here in 4 case numbers. There's 2 different things going on. It's new charges and violations of probation in 24 CF 1803 and 23 CF 2117. It's new law charges in 25 CF 141 and 24 CF 2702. We set it over from pretrial plea or continue today. I'm trying to work it out. And I'm still working with Mr. Gomez. I'd like to go through the score sheet in more detail. I'd also like to sit down and go through some credit issues with Mr. Hall. So I think that that's the long way to ask for a continuance, but I'd like to go ahead and backstop a VOP evidentiary hearing on the October 16th date, if we have time to do it.
All right, so set it on the 16th, and then we'll deal with the status of the other cases after the hearing on the 16th.
I'm pretty confident that we're going to resolve the matter, but I want to backstop it with an evidentiary hearing.
Okay.
To make sure that we're moving forward. And if we could just address the other 2 cases as the status of the VOP evidentiary date if we don't have a plea sooner than that.
So I think we're pretty piled up in the afternoon of the 16th, aren't we?
I'll defer to the state.
Yeah, I think the 23rd would be better if we want to backstop it with an evidentiary. Say again? Granted. Set all cases on the 16th with the idea that we'll have a VOP evidentiary on the, which one does?
24 CF 1803 and 23 CF 2717.
Okay, so both of the VOPs.
Yes, Judge, if we could just go ahead and set them both.
All right, and all the other cases will travel with for status.
Yes, Judge.
Okay, all right, very good. That's at 2:30.
Marcus Thompson.
Judge, this is Marcus Thompson before the court. The new law case is 25 CF 1196. There are 2 violations of probation tracking along with 22 CF 1938, 23 CF 1214. And we'd asked Madam Clerk to put a misdemeanor case number on this docket as well.
I also show 24-18-24.
As a violation of probation?
I'm not sure. I just got 4 cases, 1196, 1824, 1214, and 1938.
Correct. And we'd set it over today, plea or continue. I still need to work with Mr. Snell on bringing this in for a resolution. The lab report came back in 25 CF 1196 as not trafficking. It came back to likely possession of another substance. Procedurally, I'm going to ask to continue the matter, but I believe that this is something that I can work with the state and get into an earlier resolution. I've told Mr. Thompson in confidence that I'm going to try to get something done by the end of the week. But procedurally, I like to continue it, and as soon as we have that disposition, we can add it back on.
All right, State?
No objection.
All right, and so what's the misdemeanor case number we want to travel with? Just that way Madam Clerk can put it on our minute sheet and have be prepared next time.
Judge, that is 25 MM 2063.
All right, very good.
As soon as I get.
Justin Typton will be next.
Yes, sir. Mr. Justin Tipton is before the court in a total of 7 case numbers. The new case law are 24 CF 2217, 24 CF 1359, 24 CF 1278. The violations of probation are 23 CF 331, 22 CF 1419, 22 CF 120, and 21 CF 3157. We've reached an agreement in all of the case numbers for a negotiated agreement. That would be a plea as charged, with the exception of in the 2217 case, counts 1 and counts 5 are being null pros by the state in exchange for this agreement. The resulting guidelines, minimum guidelines, are 51.15 months Department of Corrections, and that is the agreement with the state. The 51.15 months Department of Corrections with credit for all time served. That is concurrent between all of the case numbers. That will be admitting and revoking all of the probations. It will be time served for the misdemeanor counts that are in the 2217 case. There's a total of $515 court cost in the new law cases, and a total of 4 violations of probation, which is $400, and a total of $750 cost of defense. And I totaled the whole thing for the cost today is around $26.95. Any outstanding restitution will go to civil lien, and we will reserve over the restitution in the new cases for a period of 90 days. Mr. Tipton's going to ask the court for a period of time upon his release from incarceration before those amounts are sent to collections. May I approach with the plea agreement and the score sheet?
Granted.
There are a lot of counts and a lot of case numbers. They're all reflected on the plea agreement. And it starts with how they are charged and how they are pled.
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? You can put your hand down. All right, so you heard what Mr. McKinney said, and you signed the written plea form?
Yes, sir.
How old are you?
32.
How much school do you have?
11th grade education.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read in that plea form, what Mr. McKinney just announced for me.
Yes, sir.
Now, you got two things going on today. You got your new charges and your VOPs. They're different, but we're taking care of them at the same time today. Does that make sense to you? Do you understand that?
Yes, sir.
All right. Now, as to your VOP, do you understand that you're admitting the violations?
Yes, sir.
And that says to me that, Judge, I violated my probation just the way the affidavit report says I did.
Yes, sir.
And do you understand by doing this, you're waiving your right to a trial where the state would have to prove that you violated?
Yes, sir.
As to your new charges, do you understand you're pleading no contest to those charges?
Yes.
And by pleading no contest, I understand you to say that you believe the state has the evidence necessary to prove your guilt and you're not going to contest that.
Yes, sir.
Do you understand by making that plea, you're waiving your right to a trial by jury where the state would have to prove your guilt to that jury beyond a reasonable doubt?
Yes, sir.
Now, the sentence that you're receiving in this case are all the same. They're going together concurrently with the VOPs and the new charges. And that's 51.15 months in the Department of Corrections credit for all time served, and time served on all the misdemeanors. And on your violations, that's with a revoke and terminate your supervision. You have the announced fees and costs, and the restitution will go directly to a civil lien, the outstanding restitution, and any restitution on the new cases will be decided within the next 90 days. You understand?
Yes, sir.
All right. So once you're released from prison, how much time do you reasonably think you need to get all those fees and costs paid? Is substantial? Is 24 months sufficient, you think?
Yes,
all right. Now, once the restitution is established, I may adjust that to give you an adequate time to get that paid, okay? Now, with that, has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
You satisfied with how he's represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into. I'll accept the plea with the adjudication. If you'll step over this way, please. And I still don't have anybody from the jail.
Yeah, that's fine.
This is Antonio Lamar Wise before the court in 3 case numbers, 25 CF 365, 25 CF 310, and 25 CF 187. I see I did not write 2 of the case numbers up here at the top. I'm going to do that in pen. But we have reached an agreement that handles all 3 case numbers. The agreement calls for a plea in 25 CF 365 as charged with an adjudication of guilt, 60 months Department of Corrections with credit for all time served. And for that plea, the state is going to dismiss 25 CF 310 and 25 CF 187. There will be a court cost in the amount of $817 and a $150 cost of defense. And that would be a negotiated downward departure. May I approach with the plea agreement and the score sheet?
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form?
Yes, sir.
How old are you?
42.
How much education do you have?
10th grade education.
All right. You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read in the form what Mr. McKinney just announced?
Yes, sir.
All right. Do you understand that you're making a no contest plea to this charge?
Yes, sir.
So there's 4 counts of the same thing in the 3 cases.
Correct.
The state is dismissing 2 of the cases, leaving 1 count.
1 case, 1 count.
1 case, 1 count. You on
Yes,
board
Judge.
with that, Madam Clerk? Okay. And with that, the plea agreement is the 60 months DOC, which is the maximum sentence on that, credit for all time served, right?
Correct.
All right. And then with the fees and costs. So you understand you're pleading no contest to that 1 count.
Yes, sir.
And that says you believe the state can prove your guilt and you're not going to contest it.
Yes, sir.
You're waiving your right to a trial by jury where they'd have to prove it.
Yes, sir.
You'll get the 60 months DOC, credit for time served with the fees and cost. I'll give you 24 months after you get out to get your fees and costs paid, okay?
Yes, sir.
All right. Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
You're satisfied with how he's represented you?
Yes, sir.
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea with the adjudication if you'd step over this way, please.
Manuel de Jesus Mija Garcia.
One moment, Your Honor.
Your Honor, my client had a letter. I've advised him not to read it, but he does want to address the court.
All right. Have you had the opportunity to speak to your client about what he wishes to talk about?
Yes, Your Honor.
Have you advised him regarding speaking about any facts or circumstances about the case?
Yes, Your Honor, it's not concerning that.
What would you like me to consider, sir?
I just would like to have a different attorney representing.
Okay. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Okay.
You may put your hand down. Tell me what's going on with your attorney and what you want me to do about it.
I don't want to say anything negative about anybody, I just want a different attorney. I don't feel good about the work that he's doing.
All right. For me to discharge your lawyer and give you a new lawyer, you must demonstrate that your lawyer's behavior falls below the standard required by the court and the rules of the bar.
I just don't feel comfortable with his work.
And that is not sufficient reason for me to discharge him and give you a new lawyer according to the law.
I don't want to speak negative of anybody, and if I'm not allowed to have a different attorney, then I'll just keep him.
All right, all right. So ordered.
Thank you, Your Honor, and we'll just leave this set for the November 12th court date.
So ordered.
And Your Honor, if I may put a few things on the record.
Yes.
As charged, he scores 130.200 months in the Department of Corrections with a maximum of 155 years. State's offer was to plea to the unenhanced lesser included 8270715 to counts 1 through 10, dismissing count 11, for 7 years in the Department of Corrections, followed by 10 years of sex offender probation. However, if we do proceed to trial, it would be on the enhanced version, under which he does score 130.200 months with a maximum of 155 years.
All right. Thank you. All right. We'll continue the case to 11:12.
Thank you, Your Honor.
Judge, I talked to the jail, they're gonna get him on.
All right.
He was taken off the transport list, and they assumed that meant he was taken off the court list, which is totally different thing.
Well, we were accommodating both them and us by not transporting them, but actually, they requested that, so I'm sorry for the miscomm. Maybe we need to put an asterisk on there next time or something.
Judge, can you address what we're waiting, Eddie Lewis, it's 24 CF 2716.
Eddie Lewis.
Yes, Your Honor, that would be my case. My client's not here in the courtroom, and I have not heard from him this week.
The state is going to request a KPS, Your Honor.
The issue in no bond caveus.